ಕಂಪ್ಲೀಟ್.
ನೀವು ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಯಾಕೆ ಬಂದಿದ್ದೀರಾ ಹೇಳಿ?
ಅಲ್ಲ ಆಯ್ತು
ಹಾ?
ಈಗ ಪೊಲೀಸರು ಕಾಲ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅದಕ್ಕೋಸ್ಕರ.
ಪೊಲೀಸರು ಕಾಲ್
490.
ಸರ್ ಮಾಡಿ. ಎಸ್
498
ಕೊಡಿ ಕೊಡಿ, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕೊಡಿ.
ಡೇಟ್ ಮೇ ಬಿ ಗಿವನ್. ಅವರು ಆಸ್ ಪರ್ ಸೀನಿಯರ್ ಅಂದ್ರೆ
ಹೌದು, ನಿಮ್ ಮುಂಚೆ ಕೊಟ್ಟಿರೋ ಮೆಮೋಗಳು ಅಡ್ವೊಕೇಟ್ಸ್ ತಗೋಬಾರ್ದಾ?
ನಾನು ತಗೊಂಡಿದ್ದೀನಿ.
ಅವ್ರಿಗೂ ಪೊಲೀಸ್ನವ್ರು ಕಾಲ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಆಕ್ಚುಲಿ ನಾನು ಅರ್ಲಿಯರ್ 1 week ಮುನ್ನ ಬಂದಿದ್ದೆ. ಆಸ್ ಪರ್ ಸೀನಿಯರ್ ಅಟ್ ಲೀಸ್ಟ್ ಹ್ಯಾವ್ ಇಟ್ ಆನ್ ಮಂಡೇ.
Advocates have given memos before you should be given or not? ಹೌದಲ್ವಾ?
ಲಿಸ್ಟ್ ಮಂಡೇ ಮೇಲೆ.
Because police is calling everybody.
ಮಂಡೇ ಮೇಲೆ ಅಲ್ಲ
Yes.
ಮಂಡೇ.
No, wait. Old age lady end of the list. ಸರಿ, ಓಲ್ಡ್ ಏಜ್ ಲೇಡಿ ಅಂದ್ರೆ ಎಷ್ಟು? 55? ಏನೀಗ ಅದಕ್ಕೆ? ಸರಿ, ಏನ್ ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಯಾಕೆ? ನಿಮಗೂ ಪೊಲೀಸ್ ಕಾಲ್ ಮಾಡ್ತಾ ಇದಾರ? Why do you take all numbers and keep calling them? So I should take it. Do it. Yes. ನೋಡಿ, end of the list. End of the list ಗೊತ್ತಿಲ್ಲ ಎಷ್ಟೊತ್ತಿಗೆ ಅಂತ. ಈಗ ಏನಾಗುತ್ತೆ? ಅಷ್ಟೇ ತಾನೇ? ಕೊಡಿ. ಬ್ಯಾಂಕ್ ಅಫಿಷಿಯಲ್ಸ್ ಮೇಲಲ್ವಾ? ಕೊಡಿ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ? ಬರುತ್ತೆ, ಕೊಡಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕೊಡಿ. Date. Don't ask dates, sir. Fresh matter will get. I have asked 500 matters to be posted on Monday. Beyond that, ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಕೊಡಿ. ಅಷ್ಟಲ್ಲಿ ಬಂದ್ರೆ ಬರುತ್ತೆ. 1 minute, sir. What were you doing till now, madam? Maybe till the matter went up to the stage of framing of charges, what were you doing? When the client comes to you, urgency does not spring. Give it his. Oh, 4th October. November. Please. Give it, no problem. Ad nimda? Give it. Atrocity ಹಾಕಿದಾರ? End of the list ಕೊಡಿ. ಆಯ್ತು, tomorrow. 4 weeks I have not granted. Give it any. Okay, give it, yes. Give it. Extension of entry model. Yes, sir.
Registered joint development agreement in 22. Parties are got since this too. Interim order granted by this honorable court. Side. But after they suffered an interim order,
Urgency ಏನು?
now they have registered a criminal case and the police have to summon the petitioners for purely a civil dispute.
Yeah, petitioners ಯಾರು?
They are builders.
So
On a daily basis, now they have issued a.
ಅಲ್ಲ, it can wait till Tuesday.
It's in fact, yesterday itself we wanted to move for
ಅದು ಕೊಡಿ. ಅರ್ಜೆನ್ಸಿ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಕೊಡಿ. ಇನ್ ಯಾರಿಗಾರು 230 ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಬೇಕಾ? ಕೊಡಿ.
End of the list,
ಎಲ್ಲಾರು
one end of the list.
He had completed his work and after 4 years, after completion of his work, my lord, CBI has filed a charge sheet against me stating that I have given illegal grant.
ಅಷ್ಟೇ ತಾನೆ? ಕೊಡಿ.
For framing of charges against 20.
ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ಸರ್? ಸೇಮ್ ವಾಟ್ ಐ ಟೋಲ್ಡ್ ಟು ದಿ ಲೇಡಿ. ಗಿವ್ ಇಟ್. ಎಸ್.
Settlement matter ಮೇಲೆ
ಯಾವಾಗ ಬೇಕು ಸರ್? ಯಾವಾಗ ಬೇಕು?
19th.
ಆಯ್ತು, ಬರ್ಕೊಡಿ ಅದ್ರ ಮೇಲೆ 19.
Extension, your lordship. Tomorrow, your
ಬರೋಲ್ಲ.
lordship.
Tomorrow.
Well, this is an MP MLA court matter. Regarding the Waqf board's claim over certain farmers' lands, the petitioner had posted a tweet. It was labeled as fake news because the petitioner shared a news article.
End of the list.
I am grateful.
My lord, there is an order, interim order passed by this honorable court. It has got some typographical error.
Entry model is a problem.
Typographical ಅಷ್ಟೇ error ಇದೆ.
Being spoken to.
Being spoken ಅಷ್ಟೇ.
Tension ಮಾತ್ರ.
Suppose matter, lordship
Must have
granted 30 days time, that's extension we have. Tomorrow,
End of the list ಬೇಕಾ?
tomorrow, lordship.
ನಾಳೆ ಹಾಕಿ.
Because NI has to come in that.
ನಾಳೆ.
My lord, pending matter, withdraw the
Want to
kindly.
withdraw the matter?
Yes,
Very good. ಕೊಡಿ.
kindly 19th.
19.
End of the list, my lords.
Why, sir?
The passport authorities, my lords, are not issuing the renewal of passport, my lords.
End of the list ಮಾಡಕ್ ಆಗತ್ತ.
My lord, difficulty, I'll
See,
explain.
you have to get Shanti Bhushan, I have to pass an order.
There is one difficulty, my lords. Interim order is passed by this honorable court, my lords, in the connected matter, my lords. I have not filed petition for, my lords, stay of the matter.
See,
Application
well,
is pending.
you tell me, end of the list ತಗೊಳಕ್ ಆಗತ್ತ. Is the other party obliged to come in a pending?
No, my lords,
ಇಲ್ಲ ತಾನೆ.
magistrate ಮುಂದೆ application ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ. Tomorrow it is posted for orders.
So what?
London magistrate is saying, my lords, when the stay order is passed by this honorable court,
Ah.
I cannot touch the application.
Give it.
End of-
End of the list ತಗೊಳ್ಳಿ.
Milord,
Get Shanti
in
Bhushan.
this case, Milord, I am seeking for interim order, Milord. The notice was already issued this summer court. Not net.
Pending matter.
Pending.
ಕೊಟ್ಬಿಡಿ.
Well, it's
Not-
498.
No dates. Yes.
Well, it's 498.
So what?
Well, it's, initially the matter was, actually the petition was posted, listed on 8th of August, my lords.
ಎರಡೇ ಪೆಂಡಿಂಗ್ ಫ್ರೆಶ್.
Fresh only, my lords. But initially we had filed challenging the FIR and
Oh,
now
charge sheet.
subsequently charge sheet has been
ಯಾವಾಗ
filed.
ಬೇಕು?
My lords, last week charge sheet ಆಗಿದೆ.
ಯಾವಾಗ ನಿಮಗ್ ಬೇಕು ಹೇಳಿ.
My lords, tomorrow.
tomorrow ತಗೊಳ್ಳಿ.
Summons is the next week only.
ಆಯ್ತು, ನಾಳೆನೆ ತಗೊಳ್ಳಿ.
498
Madam,
after
charge sheet
filing
withdraw
of charge sheet,
ಮಾಡ್ಕೊಂಡು.
my lords, 498. 498 after filing of charge sheet.
ವಿಡ್ರಾ ಮಾಡಿದ್ರಾ?
ಇಲ್ಲ ಇಲ್ಲ.
ಮತ್ತೆ
After filing of charge sheet, we are moving 498.
ಮುಂಚೆ ಹಾಕಿದ್ರಾ?
ಮುಂಚೆ ಹಾಕಿಲ್ಲ.
ಕೊಡಿ.
My lord,
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಕೊಡಿ ಅದಲ್ಲ.
my lord, end of the list.
Why?
406, 420 ಇದ್ರ ಪೊಲೀಸ್ನವರು ಸಿವಿಲ್ ಲಿಟಿಗೇಷನ್ ಇವ್ರ ಕನ್ಸರ್ನ್ ಇಸ್ ನಾಟ್ ಎ ಪಾರ್ಟ್ ಎಟ್ ಆಲ್. ಹೆರಾಸ್ಮೆಂಟ್ ಮಾಡ್ತಾ ಇದಾರೆ, 3 ಸಲ ಹೋಗಿ ಅಪೇರ್ ಆಗಿದ್ದಾರೆ, ಇದ್ ಮಾಡ್ತಾ ಇದಾರೆ, ಎವ್ರಿ ಡೇ ಕರೀತಾ ಇದಾರೆ. ಇವಾಗ ಅದನ್ನ ನೋಟಿಸ್, ಪೊಲೀಸ್ ನೋಟಿಸ್ ಇದ್ ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ. ಸೋಮವಾರ ಕರೀತಾ ಇದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ
ಏನ್ ಪೊಲೀಸ್ನವ್ರು ಹಿಂಗ್ ಆಗ್ತಾ ಇದಾರೆ?
ದಯವಿಟ್ಟು
ಕೊಡಿ.
ಪ್ಲೀಸ್.
End of the list.
End of the list.
Tomorrow.
I will ask you to go and appear before the police.
My lord, we have appeared and we have.
Okay, go and appear. Yes.
For reporting settlement tomorrow.
End of-
Was posted today.
ಆಯ್ತು ತಗೊಳ್ಳಿ.
It's not been listed. Now the matter and atrocities act. Petitioner is a lady who's about 65 years old.
ನಾಳೆ ತಗೊಳ್ಳಿ.
Tomorrow.
It's a pending matter.
Against 80 years old, my lord, is the grandfather of the equipment for 1 minor.
So,
Police are harassing me.
ಒಂದು ರೆಕಾರ್ಡ್ ಮಾಡಿ ಇಟ್ಬಿಡಿ ಇಲ್ಲಿ. ಪೊಲೀಸ್ ಆರ್ ಹೆರಾಸಿಂಗ್. ಬರ್ಲಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಬರ್ಲಿ.
Covered by judgment, my lord.
Give it, yes.
It's covered by judgment matter, my lord.
January 2025 covered by other.
My lord.
ಇನ್ನೊಂದು ನಾಳೆಗೆ.
Other petition.
ಕೊಡಿ ಸರ್.
Arrest, my lords.
Why?
Because I was only present at the scene of the crime is why they are.
What's the offense, sir?
My lord, cheating, my lord, cheating and criminal breach of trust.
When was the FIR registered?
9/11. I became aware of it on 11/11.
Bail ತಗೊಂಡಿಲ್ವಾ?
Bail
ಎಲ್ಲ 480 court is converted to bail court. Give it, yes.
enter the list, my lords.
ಮಂಡೆ ಏನಾಗಲ್ಲ.
My lords, end of the.
ಏನ್
My
ತೊಂದ್ರೆ
lord, because I am a financial institution, my lords. I'm a director there. That's the only reason.
then no problem at all. No urgency. Yes.
My lords, the reason because I am only providing
Take it, take it.
financial facility. I'm
I
not.
don't know when the list will end. I'll get up and go.
My lords, end of the.
Next week date may be given, my lord.
ಇಲ್ಲ ಸರ್, ಕೊಡಿ, ಮೆಮೊ ಕೊಟ್ಬಿಡಿ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಯಾವ್ದು ಡೇಟ್ ಕೇಳಿ.
Against this clearly on the speculation that we were registered at the time of COVID. One of the directors are old age people. One of them has recently suffered heart attack.
Give it.
Despite which we have been.
It will come, madam, fresh matters. Give it.
For reporting and settlement.
Tuesday or Wednesday, my lord.
It will come Tuesday or Wednesday. It will come. Give it.
Coming up before the trial for tomorrow.
ಏನ್ ಮ್ಯಾಟರ್?
After 10 years, 313 application has been filed. And
Give it. Yes. You are the complainant. Complainant has filed the 311 applications. Prosecution. Give it.
10 years.
ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್. End of the list.
For admission,
ಮತ್ತೇನ್ ಹಾಕಿದೀರಾ?
7 charge sheet challenge ಮಾಡಿ.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರಾ? ಎಲ್ಲ ಇದು CDR ಎಲ್ಲ ಇಟ್ಟಿದಾರಾ? ಕೊಟ್ಟಿದಾರ?
Preserve ಮಾಡಿದ್ದೀನಿ.
7 ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡಿ ಯಾವಾಗ? ಏನ್ ಮಾಡಲ್ಲ ಅದು.
Reporting and settlement tomorrow.
ಕೊಡಿ. Yes.
For tomorrow, my lords, I have challenged the order of appointment of
Madam.
SPP, my lords, tomorrow. On the ground of,
Why?
lords, on the basis of Shiva Reddy judgment, my lords, the remuneration and the duty of the SPP, my lords. 302, my lords, it is posted for.
When is the next date, sir?
My lords, next week, my lords.
Post this also next week, Tuesday or Wednesday hakim. Yes, call the cases.
My lord. First one, no for posting.
ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ ಬಿಡಿ. Call the case.
Number 1.
ಕೊಟ್ಟಿದ್ದೀರಿ, ಏನ್ ಮಾಡಿದ್ರಿ?
25,000.
25,000.
ಅಲ್ಲ ಎಲ್ಲ ಕೊಟ್ಟಾಗಿದೆ. 20,000
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ?
ನಮಗೆ ಟೋಟಲ್ ಆಗಿ
20 ಲಕ್ಷ ಕೊಡಕ್ಕೆ ಹೇಳಿ.
5,51,000 rupees.
51,000 ಬಂದಿದೆ ಸ್ವಾಮಿ.
As
ಬಂದಿದ್ಯಾ?
against my lord, 3,95,000 rupees is the outstanding amount. 18% interest calculate ಮಾಡಿ 5,51,000 ಕೊಟ್ಟಿದ್ದೀವಿ.
ಆಯ್ತು.
ಅಲ್ಲ.
ಬ್ಯಾಲೆನ್ಸ್ 25,000.
ಇನ್ ಎಷ್ಟು ಕೊಡ್ಬೇಕು?
ಅಲ್ಲ ಸ್ವಾಮಿ,
ಅದು ಆಚೆ
ನಮ್ಮ
ಕಡೆ.
ಪ್ರಕಾರ 21,000 ರೂಪಾಯಿ ಕೊಡ್ಬೇಕು.
ನಿಮ್
ಅವ್ರಿಗೆ
ಪ್ರಕಾರ ಎಷ್ಟು ಕೊಡ್ಬೇಕು?
51,000 ಬರ್ಬೇಕು ಸ್ವಾಮಿ.
30,000 ಡಿಫರೆನ್ಸ್
25,000 ಹೇಳಿರ್ತಾರೆ ಸ್ವಾಮಿ.
ಅದನ್ನೇ ತಂದಿಲ್ಲ.
25 ಅಮೌಂಟ್.
ತಗೊಂಬಿಡಿ ಅದನ್ನ. ಅದ್ ತಗೊಂಡ್ಬಿಟ್ಟು just call it quits. If I had permitted you to go and avail the remedy of 421, you would have been languishing for 4 years.
No, I am happy with this.
ಗೊತ್ತಾಯ್ತಲ್ಲ? You are happy. So be happy.
But now she is having more checks of me. But
ಅದ್-
she is denying that.
One minute. Is that arising out of the same transaction?
No, my lord.
Arising out of same transaction.
ಅಲ್ಲ.
As a security.
ಅಲ್ಲ, is the cause of action the same? Tell.
No.
ಅದ್ ತಪ್ಪಾಗಲ್ವಾ? ನೀವು ಇದನ್ನ ಕೊಟ್ಬಿಟ್ಟು ಅದನ್ನ ಕೇಳಿದ್ರೆ ಅದು ಸಪರೇಟ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಆದ್ರೆ ಇನ್ ಕೇಸ್ ವಾಟ್ ಕ್ರೈಮ್ಸ್ ಆರ್ ಯು ರಿಜಿಸ್ಟರಿಂಗ್ ನೌ?
No, my lord. They have filed a wrong complaint against me before
Not the-
JP Nagar police station. That is a PCR case.
So what checks are you holding now?
ಅಲ್ಲ, ಅವ್ರು ಹೇಳೋದು I am holding 3 checks ಅಂತ ಹೇಳ್ತಾರೆ. That has been already they have taken a police complaint has been registered.
Not-
PCR has been registered against me.
Ah.
And the charge sheet has been filed by
Against you
against me, my
for
lord.
theft?
They misusing and theft ಅಂತ ಹೇಳಿ complaint.
ಅದು ಕಂಟಿನ್ಯೂ
Against
ಆಗಿದೆ.
her and against her sister.
Whoever it is, I will record that the other checks are subject matter of that charge sheet or whatever. ನಾವು ಅದನ್ನ ಹೆಂಗ್ ಸೆಟಲ್ ಮಾಡಕ್ಕಾಗತ್ತೆ?
True, but
ಅಲ್ಲ, ಅದ್ ನೀವು
she did-
ಮಾತಾಡಿದ್ರೆ ನಾನು ಸೆಟಲ್ ಮಾಡ್ಬೋದು.
but she is not agreeing for that. In fact, madam, she has sent
Already filed a
WhatsApp
false
through
case
WhatsApp these checks. Madam, according to her, she is having these checks. Photo,
No.
madam, she has said.
Are those checks the subject matter of a complaint given by you? ಹೌದಾ ಇಲ್ವಾ?
ಹೌದು, PCR ಆಗಿ CC ಆಗಿದ್ರಲ್ಲಿ.
ಹೌದಾ?
madam, that is
ಮತ್ತೆ
subject matter.
ಅದ unless you talk to them, how can we settle it? ಇದ್ರಲ್ಲಿ ಮಾಡಕ್ಕಾಗತ್ತ? Don't think in giving something you
True,
can
but,
take away
but
something.
when I am paying 18% interest.
That's all right, sir. You sit and talk to her. I will post this on Tuesday. You sit and talk to her.
ನೋಡಿ,
ನೀವ್ ಹಾಕಿರೋ ಕಂಪ್ಲೇಂಟ್ ಅದು ನೀವೇ ವಿಡ್ರಾ ಮಾಡ್ಬೇಕಾಗಿ.
ನೀವು ವಿಡ್ರಾ ಮಾಡಿ ಇದು ಮಾಡಿ.
ನೀವು ಕಂಪ್ಲೇಂಟ್
ಚೆಕ್ ವಾಪಸ್ ಕೊಟ್ಟರೆ madam, we will not settle.
ಕಂಪ್ಲೇಂಟ್ ವಿಡ್ರಾ ಮಾಡಿ ಚೆಕ್ ವಾಪಸ್ ಕೊಡಿ, ಮಾತಾಡಿ. ವಿಲ್ ಪೋಸ್ಟ್ ಇಟ್ ಆನ್ ವೆಡ್ನೆಸ್ಡೇ ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್.
ಅಲ್ಲ, ಇದು ಕ್ಲೋಸ್ ಆಗ್ಬಿಡಿ. ಯಾಕಂದ್ರೆ that is
ಬೇಡ.
a different cause of action.
Wait,
They have registered a
wait.
PCR against me.
ತೊಂದ್ರೆ ಇಲ್ಲ, ಮಾತಾಡ್ಕೊಂಡು ಇದು ಹಿಂಗೆ ಇರ್ಲಿ. 25,000 ಇಸ್ಕೊಳ್ಳಿ. Learned
ಕೊಟ್ಟಿದ್ದೀನಿ.
counsel for the
That may be recorded.
petitioner hands over cash
Cash of 25,000.
cash of 25,000 to the respondent's advocate. The same is acknowledged, receipt of which is acknowledged. ಅಷ್ಟೇ.
And petitioner is present, madam.
ಅದ್ಯಾಕೆ? I have not called the petitioner.
20th.
List on 20th in the fresh matters list. ಅದನ್ನ ಮಾತಾಡ್ಕೊಂಡ್ ಬನ್ನಿ. we'll do
Later
it.
present before the court, not because. she
ಯಾಕೆ?
has-
ಭಯ ಆಗ್ಲಿ ಅಂತ.
ಅಲ್ಲ, ಭಯ ಆಗ್ಲಿ ಅಂತ.
ಮತ್ತೆ?
ಈ ಚೆಕ್ಸ್ ಬಗ್ಗೆ ಅವರೇ ಇದ್ರೆ.
ಇಲ್ಲ. Yes.
ಮಚ್ಚ
You keep the party present. Yes, counsel. Keep the party present. Settle ಮಾಡ್ಕೊಳ್ಳಿ ಎಲ್ಲ. ಏನ್?
ಆಯ್ತು ಸ್ವಾಮಿ, that's
What is all
next
this?
date I'll keep present.
Yes. Next.
Number 2.
ಎಲ್ಲಿ ಕೆಪಾಸಿಟಿ ಟು ಪೇ ಇಲ್ವೇ ಇಲ್ಲ?
My lords, they have not challenged that capacity to pay.
I
That's
am
not their
asking,
defense.
I am
under-
asking you.
My lords,
I am asking you.
my lords, when that is not their defense and it is not the stage to take the defense, the stage to take the defense is at the cross examination.
Then I will record and dispose this, saying he has not demonstrated capacity to pay. The court will consider that also.
Humble submission.
ಆಗ್ಬೋದಾ?
I would state that that would not be the proper course for the reason being.
No problem. These are the questions asked. I have passed the orders. I will record the orders. I will say that you have not demonstrated the capacity to pay 85 lakhs cash.
My lords,
And because the defense, this check was given to someone else.
my lords, probably when he has taken a defense that he has given it to somebody else, and when the presumption is operating in favor of me,
No problem.
when the
Absolutely no problem. Let the presumption be rebutted there only. No
Lords,
issue.
the presumption should be rebutted on the theory which he takes.
Whatever.
We cannot, my lords, in this,
Now,
before
a-
this forum,
A little extra theory we will add to that rebuttable presumption.
it would be, my lords, presuming the defense.
Why are you afraid, sir? You prove that you had money to.
My lords, if he were to take the defense and that
Now he
rebuts
will
it,
take that defense. I will permit him to take that defense.
my lords, let him. But it may not come as an order, please.
No. I will permit him to take that defense. I will.
Whatever defense it may be permitted.
I
but
will
we cannot
record.
point, please,
Sir,
my lords,
I will
that this would
record
be
the
the
orders
defense.
passed by this court. And permit him to take the defense there.
My lords, my humble submission.
Yeah, why are you
Alla.
fighting shy of that?
My lords, he may take any defense available,
ಪರವಾಗಿಲ್ಲ.
but
I will
to
permit him
point
to
out
take
that
the
this is a defense you can take, that would be wrong.
ಅಲ್ಲಿ ಹೋಗಿ this is illegal, you can't take that defense ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ.
Let him take. Any defense he takes. But if this honorable courts were to point out that this defense you
So I will
make,
only record these submissions and
this
permit him
honorable
to take
court
that.
should, this is my humble submission that this honorable court may not pinpoint him that this is a defense available to you.
No problem. I will. No, I am not pointing a pin at all.
When, my lords, if he had made a reply stating that this is the defense that you don't have capacity to pay, my lords, I would assume that. But when his defense is only not that,
The longer you fight shy, the shorter your case gets.
my lords, certainly, subject to what defense he takes.
He will take it then.
He can take any defense, but
Yes.
let it not be pinpointed.
He can
Is
take
only
any,
my-
he can take any and many defense, including this.
He may, but it
Yes.
may not be pinpointed by virtue of this order.
Not, ಅಲ್ಲೇ ತಗೊಳ್ಳಿ sir ಎಲ್ಲ.
Complaint before the police
ಯಾಕೆ?
against the
ಹಾ.
petition and
ಅದೆಲ್ಲ ಅಲ್ಲೇ ತಗೊಳ್ಳಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. I will record what has happened here, that's all.
bank statement is produced. There is no.
ಎಲ್ಲ ಅಲ್ಲಿ ತಗೊಳ್ಳಿ. The petitioner is before this court calling in question
There is no document.
the
before
order dated, the proceedings in CC 494 of 2023 registered for offense punishable under section 138 of the Negotiable Instruments Act. The learned counsel for the petitioner, heard so and so. The learned counsel for the petitioner inter-alia would seek to project the capacity of the respondent in advancing payment of 85 lakhs by way of cash.
That is not his,
ಅಲ್ಲ, that's what,
that is not his case in the entire grounds. please.
content ಅಂತ ಹೇಳಿ.
Even in its entire
ಒಂದು
petition.
ರೆಸ್ಪಾನ್ಸ್ ಹೇಳ್ತೀನಿ ತಾಳಿ. So by way of cash. This court, owing to the said submission, had one ನಿಮಿಷ,
It is not his grounds.
had
please.
passed the following order on 3/9/2024. ಅದೊಂದೇನಾ? On 3/9/2024. Since the matter is pending before the learned counsel appearing for the respondent would refute the submission contending that the ground urged in the petition is not what he is projecting as a contention, nor that is the reply to the complaint when, reply to the notice when was issued by the respondent complainant. Be those submissions as they are, all these contentions projected or pleaded can be pleaded before the concerned court. It is, this court has no reason to believe that the concerned court would not look into those pleadings, look into those contentions, answer them in accordance with law, leaving open all the contentions to be taken by the petitioner before the concerned court. The petition stands disposed.
Court time is.
Huh?
There is no document produced before the court.
ಅಲ್ಲಿ ಮಾಡಿ ತೊಂದ್ರೆ ಇಲ್ಲ. ಎಸ್, ನಿಮ್ಗೆ ಏನ್ ಬೇಕು ಕೇಳಿ.
Hey, good.
ಸ್ಟೇನಾ
ಅಲ್ಲಿ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್
ಅಲ್ಲಿ ತಗೊಳ್ಳಿ ಸರ್ ಅಂದ್ರೆ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದೀನಿ, ಸ್ಟೇ ಅಲ್ಲಿಂದ ಬಂತು. ಎಸ್, ಯು ಟೇಕ್ ಆಲ್ ದಟ್ ಗ್ರೌಂಡ್ಸ್ ದೇರ್. ಅದು ಮತ್ತೆ ಇಲ್ಲೇ ಬರುತ್ತೆ, ಹೋಗಿ. ಎಸ್.
Number 3. 498A.
498A.
Stay is already granted to the other accused except for one.
Husband, I am not granting. ಓ, ಇರ್ಲಿಲ್ಲ, ಅದ ಇದು. ಎಸ್. This court on 4/11/2024 had in fact granted an interim order of stay. It was not uploaded on the score that the application for stay was not put up with the petition. On verification, it is found that the application for stay was filed before the registry on 25/10/2024 itself. Therefore, it is irresponsibility or folly of the registry to not have put up the application seeking vacation of the interim order along with the petition. In that light, there shall be an interim order of stay of all further proceedings, where all the other accused except the husband accused number 1, failing which it would run foul of the judgment of the apex court in the case of Kailas Ben versus so and so 2024 SSC online SC page 2621. Yes, post the matter in its usual course in admission. 10 lakhs.
8 minutes.
He is in prison. ಯಾರಿಗೆ ಪೇ ಮಾಡಿ? ರಿಜಿಸ್ಟ್ರಿಗೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರಾ? ಎಷ್ಟಿದೆ ಅರಿಯರ್ಸ್? I told that also to be calculated.
The arrears which the respondent is showing is 43 lakhs, my lords.
Hmm.
My lords, my instructions are that he has paid some amount. I am
No,
unaware.
if you are let outside and they will, you impossible to trace you. You will escape from Google also.
No, my lords, I will undertake that he'll be present on every day
Where?
before the court.
Yes. Civil prison. But ಆದ್ರೆ 43 ಲಕ್ಷ ಜಾಸ್ತಿ ಆಯ್ತಲ್ಲ.
ಅಲ್ಲ,
ಇನ್ನೊಂದು 10 ಡೆಪಾಸಿಟ್ ಮಾಡಿ.
The quantum is not ascertained. It is only the respondent number 2's version that. it is
ಆಯ್ತು 20 ಆದ್ರೂ ಬರುತ್ತಲ್ಲ.
ಅಲ್ಲ, so
20 lakhs ಆದ್ರೂ ಬರುತ್ತಲ್ವಾ?
Maintenance award ಆಗಿರೋದೇ 5,000 per month ಸ್ವಾಮಿ.
ಎಲ್ಲಿಂದ?
2015 ಇಂದ.
ಅಂದ್ರೆ 60,000 per year.
ಹಾ.
ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು?
9 years.
996
4.5 lakhs.
5,40,000.
ಅಲ್ಲಿ ಮೆಡಿಕಲ್ ಬಿಲ್ಸ್ ಅಂತ ಹೇಳ್ತಾರೆ. What is the quantum of medical expenditure is not
Anyway,
ascertained.
The petitioner, this court on 11/11/2024 had passed the following order. The Learned Counsel submits that the maintenance awarded to the wife by the concerned court was rupees 5,000 per month in the year 2015. Even if that is put together, it would amount close to 6 lakhs till now as arrears. The petitioner has been in prison for the last 3 years due to
Medical bill.
due to non-payment. What is the real arrears is the medical bill of the wife and child.
Only the child, my lords. The child is dead now.
Of the child. Why? Because of your carelessness, it is
No, my
passed
lords.
away.
No, my lords. The child had some birth defect. Due to liver failure, the child passed away.
When?
Yes, my lords, in 2000.
Anyway, we'll stay this now. 10 lakhs is deposited. We'll direct deposit.
Another 10 maybe.
Huh?
Another 10 maybe.
Oh, that's what it is.
2014, my lords.
14. Even before, what medical bills are you talking of after the death of the child?
My lords, the order says so, my lords. The order does not define the quantum.
Let's see. Emergent notice to the respondent, returnable by second respondent. Returnable by the 10th of December. List on 10th of December in the fresh matters list. Till such time, what stay have you sought?
Lords,
Till such time, there shall be an interim order of stay as prayed for in the petition.
my lords, I sought for stay of further proceedings. He may be let out, my lords.
ಅದೆಲ್ಲಿದೆ ಕೇಳಿದ್ದೀರಾ?
ಕೇಳಿದ್ದೀನಿ sir.
ಕೇಳಿದ್ರೆ ಅದು as prayed for. Yes. As prayed for. It is made clear that the petitioner shall be present before this court on 10th of December 2024, failing which the order would be rescinded. Yes. Next. A deposit, the counsel for the petitioner, ಮೇಲೆ ಬರ್ಬಿಡಿ. Will deposit the demand of 10 lakhs before the registry in the next 24 hours.
My lords, deposit,
ಮಾಡಿದ್ದೀರಾ ಆಲ್ರೆಡಿ?
TD ಕೊಟ್ಟಿದ್ದೀನಿ sir.
ಸರಿ ಅದೇ ಮಾಡಲಿ. ಸೇಮ್ ಇಸ್ ಟೇಕನ್ ಆನ್ ರೆಕಾರ್ಡ್ ಅಂತ ಮಾಡಿ. ಇಟ್ ವಿಲ್ ಬಿ ಏನು ಮಾಡ್ಬೇಕು ಡೆಪಾಸಿಟೆಡ್ ಬಿಫೋರ್ ದ ರಿಜಿಸ್ಟ್ರಿ. ಇಲ್ಲ ತಗೊಂಡ್ರಿ ರಿಜಿಸ್ಟ್ರಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿಬಿಡಿ. ಮಾಡಿದ್ವಿ.
ಆಗಿದೆ sir.
Same is taken on record.
My lords, one clarification, my lords. I had sought 2 different interim orders, my lords. I'll seek only for stay of proceedings so that he'll be let out, my lords.
There shall be an interim order of stay of all further proceedings pursuant to the all further proceedings in so and so on part. The impugned 421 proceedings. Yes.
Lords, a direction to let him out.
That's consequential. In the light of the stay granted, let it be out 3 ವರ್ಷದಿಂದ ಒಳಗಿದ್ದಾರೆ. Civil prison. In the light of the interim order of stay granted, the petitioner will be let out of the civil prison till the next date of hearing. Yes, next.
Fine.
The petitioner, my lords. Was the petitioner is punished with section 354C, 354D, subclause 1, 506, 509, 120B and
Yes,
43
sir.
and IT Act of 67A, my lords.
Videos ಎಲ್ಲ ಗಂಡನಿಗೆ ಕಳ್ಸಿದ್ರು.
That's the Indo.
Videosನೆಲ್ಲ ಗಂಡನಿಗೆ ಕಳ್ಸಿದ್ರು.
That's the only allegation against me. I'll take my lordship to charge sheet at page number. At page number 27, my lord, of the petition. ಈ ದೋಷಾರೋಪಣೆ ಪಟ್ಟಿಯಲ್ಲಿ ನಮೂದಿಸಿರುವ A1 ಆರೋಪಿಯು ಫಿರ್ಯಾದಿದಾರರ ಪರಿಚಯವಾಗಿ ಸ್ನೇಹವನ್ನು ಬಳಸಿ ಫಿರ್ಯಾದಿದಾರರೊಂದಿಗೆ ಕಳೆದ ಖಾಸಗಿ ಕ್ಷಣಗಳನ್ನು ಅನುಮತಿ ಇಲ್ಲದೆ ವಿಡಿಯೋ ಚಿತ್ರೀಕರಣ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ನಂತರ
ಕಳಿಸಿದ್ರಿ ಆಮೇಲೆ?
I'm A3 in this matter. I have not recorded the video. I have not taken the video. I have not sent the video to anybody. Only message that I have sent is in the charge sheet now. That page number.
Charge sheet material ಇದೆ.
ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
Video ಏನಿಲ್ಲ.
She also sends it to.
No, ನಿಮ್ charge sheet material ನೋಡಿ.
Was at page number 21 of the charge sheet, my lords.
Your what? Lavanya.
Lavanya. The phone number may be tallied at page number 36, my lords.
Who has sent this video?
Video ನಾನು ಕಳ್ಸಿಲ್ಲ ಸ್ವಾಮಿ. Video was sent by.
ಕಳ್ಸಿರೋದೆಲ್ಲ.
ಇಲ್ಲ, video was sent by wife of the A1. ಅದು ಮೋನಿಕಾ ಅನ್ನೋರು. The complainant A1 had an illicit relationship that was recorded. And A2 has found the video on A1's mobile phone, and then she has taken it to her phone, and then that has been sent back to a complainant's husband, my lords. The whole act was done by the A1 and A2. A3 is nowhere. ಇಲ್ಲಿ FIR file ಮಾಡ್ಬೇಕಾದ್ರೆ A3 ಆಗಿರ್ತಾರೆ. At the time of filing charge sheet, she has been made as at the time of FIR, she is made as A4. Charge sheet file ಮಾಡ್ಬೇಕಾದ್ರೆ A3 ಆಗ್ತಾರೆ. This is the only message.
No, the videos are horrible. Who has sent it is the
This message is sent by Lavanya.
A1.
213. A1 records it.
3 no ಇದೆ. Yes, sir.
ಇಲ್ಲ, 3 ಕಳ್ಸಿಲ್ಲ ಸ್ವಾಮಿ. 3 ಕಳ್ಸೋದಕ್ಕೆ there's no evidentiary value at all. See, 3 ಕಳ್ಸಿದ್ರೆ.
That will see. That's a matter of evidence.
Because this is the only message has been sent.
Yes.
ಈ ವಿಡಿಯೋ ಕಳ್ಸೋದು ಬಂದ್ಬಿಟ್ಟು ಮೋನಿಕಾ ಫೋನ್ ಇಂದ. That has also been.
ಎಲ್ಲ ಮೋನಿಕಾ ಹೌದು.
ಮೋನಿಕಾ ಫೋನ್ ನಂಬರ್ ಇದೆ ಮೇಲೆ 564 ಅಂತ.
ನಿಮ್ದು Motorola Moto Gold.
ಹೌದು ಸ್ವಾಮಿ. That phone number is
Moto G5 Plus.
Yes, that is 598 phone number at WhatsApp message ಅಲ್ಲಿ. At page number 21. ಆ ಮೆಸೇಜ್ ಅಲ್ಲಿ ಬರೀ only so much has been produced. But there's no other video which has been received by her nor sent from her phone to anybody else.
Why were you made the accused then?
Well, it's because I was made an accused because this message was sent by me. She has only tried to harass me ಅಷ್ಟೇ.
Yes, Jagdish.
Not produce the entire charge sheet material now. Let me.
ಕೊಡಿ ಎಲ್ಲ.
Charge sheet already ಇದೆ ಸ್ವಾಮಿ. Please don't.
ಬೇರೆ material ಏನ್ ಕಲೆಕ್ಟ್ ಮಾಡಿದೀರಾ ಕೊಡಿ. List on Wednesday in the fresh matters list.
Because even the dates are there's a delay in the filing charge sheet. There's almost a delay of 4 years, 9 months, my lord.
4 charge sheet. That's okay. We'll see. ನೀವೇನ್ ಮಾಡ್ತಾ ಇದೀರಿ ಸರ್? 4 years 9 months ಇರೋದ್ 4 ವಿಡಿಯೋ. ಮತ್ತೆ
ಯಾವ ವಿಡಿಯೋ ನನ್ನ ಫೋನ್ ಅಲ್ಲಿ ಸಿಕ್ಕಿಲ್ಲ, ಬರೀ A2 ಫೋನ್ ಅಲ್ಲಿ ಸಿಕ್ಕಿರೋದು ಅಷ್ಟೇ.
4 years what did you do?
Verify. We'll ask the officer.
Wednesday in
4/1/2024.
Wednesday in the fresh matters list. Yes, next.
Please, my lord.
311 application. We'll allow this.
CW3. Yes.
I filed memo for deleting it.
Yes.
Respondent
The petitioner is before this court calling in question an order dated 5/8/2022 by which an application filed by the petitioner under section 311 of the CrPC to recall CW3 comes to be rejected in CC 36714 of 2011.
Yes.
ಇನ್ನೂ ನಡೀತಾ ಇದೆ. ಏನು offense ಏನು?
Under the Money Laundering Act, my lord.
Money laundering.
Money lenders act.
Money Lenders Act.
Money
lending money laundering ತುಂಬಾ difference is. Yes. The petitioner gets embroiled in a crime in crime number 24 of 2011 for offenses punishable under section 5 so and so. First synopsis alla ide. The issue in the list does not pertain to the merit of the matter or the defense of the prosecution. The petitioner files an application under section 311 of the CrPC seeking recall of CW3 on 28/7/2022. The learned magistrate rejects the application on 5/8/2022. This is called in question by the petitioner before the court of session in Court of Session,
Criminal revision petition.
ಎಲ್ಲಿದೆ ನಂಬರ್ ಅದು? In criminal revision petition
24 of 22, my.
424 of 2022, that comes to be rejected by the Court of Session on 25/9/2024. It is this that has driven the petitioner to this court in the subject petition. Who is CW3?
CW3 is the major witness, my.
The learned counsel appearing for the petitioner submits that one opportunity to further cross-examine CW.
Examination.
Huh?
Examine, you've been drawn.
Examine. The learned counsel for the petitioner, Shri Muniappa, submits that there was no opportunity to examine CW3. Therefore, it is imperative that he was permitted to be examined, as there cannot be permitted to be examined. He would submit that if one opportunity is granted, he would finish the he would examine him and close the proceedings insofar as he is concerned, as he is the complainant on the said date itself. The learned ನೀವಿದ್ದೀರಾ? The learned additional.
In fact, the application filed by us.
The learned additional SPP submits that the application was preferred by the prosecution seeking examination of CW3 for the, as it was necessary to prove the offences against the accused. The same could not have been rejected in the teeth of the reasons so rendered to file the said application. I have given my so and so. The afore narrated facts are not in dispute. The petitioner is the complainant, the respondent, the respondent, the accused. The accused gets embroiled in a crime number 24 of 2011 for the said offences on a complaint registered by the petitioner on 29/1/2011. During the proceedings, the prosecution files an application under section 311 seeking examination of CW3. This comes to be rejected on the ground that the matter is at the stage of recording of 313 statement. Recording of 313 statement. The reason so rendered by the concerned court in rejecting the application filed by the prosecution to examine CW3, who was not at all examined, runs foul of the law laid down by the apex court in the case of Varsha Garg versus so and so, 2022 SEC online SC page 986. Therefore, I deem it appropriate to grant one opportunity to the prosecution to examine CW3 and conclude the cross-examination on the date fixed by the concerned court. Since the issue is of the year 2011, I further deem it appropriate to direct the concerned court to conclude the proceedings within an outer limit of 6 months, if not earlier. Ordered accordingly.
Memo file to delete R1.
Separate order sheet, my body. Memo, learned counsel of the petitioner has filed a memo to delete R1 from the array of respondents. The memo is taken on record and said so and so is deleted at the risk of the petitioner. Admadi, konege, writ petition is allowed. Criminal petition is allowed. The order dated so and so stands quashed. Order the concerned court is directed to permit the prosecution to examine CW3 on a date fixed by it, and the examination shall conclude on the same day. It is made clear no further opportunity of filing an application of the kind that is now filed will be granted to the prosecution.
Reason was not, they have not secured CW3. Direct the prosecution to secure CW3 and examine.
All right. Secure CW3 and examine and conclude the examination. Yes. Next.
7.
I'm representing respondent 2. I request for a short accommodation. Idralli no petition copy has not been served upon
We've
us.
already sent a emergency notice. We'll give a copy of it.
What is that?
What this?
Yes.
Interim order itself.
The name, madam.
I would request to file my statement of objections.
What's your name?
DA. DT.
DA?
DA. No, right.
DA anta baribeka? Yes.
Sorry.
So learned
Yes,
counsel
where-
so and so undertakes to enter appearance for the respondent, petitioner to serve set of papers upon the aforesaid counsel. The learned counsel would seek 2 weeks' time to file statement of objections. Objections, if any, in the next 2 weeks. Interim order subsisting will continue till the next date of hearing.
Acha.
Idu 311. Alva.
Appeal was filed, my lord, where we are required to pay the amount of 20%.
Jambu Bandari.
Mallikarjun,
Huh?
8,
Seal number 8, Abhinay, Nimda.
Mallikarjun.
Jan Jambu Bandari in the judgment.
Yes, yes, ma'am. Sorry, my lord. Just 20%, my lords, may grant me 10 days time to deposit.
Emergent notice to the respondent returnable by the 11th of December, list on 11th of December in the fresh matters list. The petitioner is before this court calling in question the condition imposed by the appellate court while suspending the sentence. The condition is deposit of 20% of the amount of check and fine. The condition so imposed runs foul of the judgment of the apex court in the case of Jambu Bandari versus so and so 2023 10 SEC page 446. In that light, there shall be an interim order of stay of the said condition till the next date of hearing, subject to condition that the petitioner, learned counsel with the petitioner submits if 10 days time is granted, he would fulfill the condition. With all this, there shall be an interim order of stay till the next date of hearing. Avat muks tanbude dedi. Next.
Nice.
I permission to deposit the amount for the appellate.
Marbutu get evidence.
Waiting a little bit, my lord, accept madala.
The petition alone barkonbidi. The petitioner is at liberty to deposit the amount before the concerned court by the next date of hearing. It infractions close manava.
Petition.
Release of tractor.
As per merger, vehicle number was not there, your lordship, number plate. That is the observation made while rejecting.
Vehicle has been registered in the month of April, my lord.
Page
And
17.
subsequently, the document has been produced.
Yardo tractor yargo kodakagalla.
Illa, I have produced the RC book also, my lord. And even
RC book kottidire.
even I have original RC.
Verify madam. List on Wednesday in the fresh matters.
One submission, my lord.
You know.
I have produced the RC book and
As
also-
per merger, there was only chassis number and engine number.
Let her look into it.
no,
and
yeah,
some
this RC, original RC book also.
list on Wednesday in the fresh matters list. Yes, next.
10.
Further cross of PW3.
Turned hostile.
Huh?
Hostile witness.
Matten cross examination, hostile witness.
She is
ಇಲ್ಲ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹೋಸ್ಟೆಲ್ ವಿಟ್ನೆಸ್ ನೀವು ಮಾಡಬೇಕು.
ನಾವು ಮಾಡಿದೀವಿ, ಆಮೇಲೆ ಅವರು ಮಾಡಿದ್ದಾರೆ, ನಮ್ಮ
ಮತ್ತೇನ್
ಕ್ರಾಸ್
ಬೇಕೀಗ?
ಮಾಡಿದಾಗ್ಲೂ ಸಹ ಸಪೋರ್ಟ್ ಮಾಡಿಲ್ಲ.
She is admitted the complaint on the exhibit.
ಯು ಕಾಂಟ್ ಆರ್ಗ್ಯೂ ಆನ್ ಮೆರಿಟ್ಸ್ ಆನ್ ದಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಿ ಈಗ?
Page 55, my lord, you will. Page 55.
311
evidence.
application has been rejected by the trial court, my lordship. She is the some of the incriminating evidence against the
PW3 ಯಾರು ಸರ್?
mother of the victim, my lordship.
ಎಷ್ಟು ಸರಿ ಕರೆದಿದ್ದೀರಾ ಅವ್ರನ್ನ?
ಇಲ್ಲ ಕರೆದೇ ಇಲ್ಲ, ಸೊ ಇದೇ ಫಸ್ಟ್ ಟೈಮ್ ಅಪ್ಲಿಕೇಶನ್.
Page 55, your lordship may see. She is completely turned hostile.
ಯಾರ್ ಮದರ್?
ಮದರ್.
ಮತ್ತೇನ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕು ನೀವು?
ಸಮ್ ಆಫ್ ದಿ
ದೇ
ಇನ್ಕ್ರಿಮೇಟಿಂಗ್
ಹ್ಯಾವ್ ಟು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಸರ್.
ಅವ್ರು ಮಾಡಿದ್ದಾರೆ ಸುಮ್ಮನೆ ಅದರಲ್ಲಿ ಒಂದು ಎಕ್ಸಿಬಿಟ್
ಇಫ್ ಶಿ ಹಸ್ ಟರ್ನ್ಡ್ ಹೋಸ್ಟೈಲ್ ಅಂದ್ರೆ ಐ ವಿಲ್ ರೆಕಾರ್ಡ್ ಇಟ್ ಅಂಡ್ ಕ್ಲೋಸ್ ಇಟ್ ನಾಟ್ ನೆಸೆಸರಿ ಅಂತ.
ಎಕ್ಸಿಬಿಟ್ P5 ನ ಮಾರ್ಕ್ ಮಾಡಿಸ್ತಾರೆ. ಪ್ರಯರ್ ಟು ದಿಸ್ ಕಂಪ್ಲೇಂಟ್ is a complaint lodged by my wife.
Exhibit P5 also she denies it. I have not given such statement, your lordship, if page 57 at paragraph 4.
If she has turned completely hostile, what is your problem? You are creating problems by filing this petition.
Exhibit P5 ರಂತೆ ನಾನು ಹೇಳಿಕೆ
This petition will become counterproductive. ಯೋಚನೆ ಮಾಡಿ. ಹಾಸ್ಟೈಲ್ ಆಗಿರೋದನ್ನ ನೀವು ಮತ್ತೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ ಮತ್ತೆ ಅವ್ರ ಪರವಾಗಿ ಹೇಳ್ಬಿಟ್ಟಾರ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಸೆಲ್ಫ್ ಗೋಲ್ ಆಗ್ಬಾರ್ದು.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವ ಟೈಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್?
ಸರ್ 22nd in the fresh matters list. No order.
11.
agreement and
A3 420 heard the learned senior counsel so and so. ಏನಾದ್ರು ಇದೆಯಾ ಮೇಡಮ್?
It is a premature, your lordship. No.
ತೊಂದ್ರೆ ಇಲ್ಲ.
10th ಗೆ.
ಡೆತ್
ಅಲ್ಲ, just 1 month ಆಗಿದೆ ಅಷ್ಟೇ. It is just under investigation.
is A3. The petitioner is accused, heard the learned senior counsel Panindra appearing for the petitioner. The petitioner is accused number 3 is alleged of offences punishable under section 406 and 420 of the IPC. A perusal at the complaint would not indicate any act of the petitioner that would become the ingredients of both 405 and 415 for it to become an offence under section 406 and 420 of the IPC. Therefore, there shall be an interim order of stay of further investigation by the petitioner till the next date of hearing.
11 and 12 are
Same, both.
Accused number.
Accused number
ಅಕ್ಯೂಸ್
3,
ಬೇರೆ ಅಷ್ಟೇ. ಅಕ್ಯೂಸ್ ನಂಬರ್ ಅದರಲ್ಲಿ
2 and 3. ಇದರಲ್ಲಿ
2 ಮೇಲೆ ಏನಿಲ್ವಾ?
let's
2 ಮೇಲೆ ಏನಿಲ್ವಾ? ಯಾಕೆ?
except saying MOU is signed,
ಎಸ್.
please.
ಅರುಣ್ ಶಾಂತಿಭೂಷಣ್ 13.
13.
ಏನಕ್ಕೆ ಅರ್ಜೆಂಟ್ ಆಗಿದ್ದೀವಿ?
ಇದು is a coffee planter. A person engaged by a purchaser of timber suffered injury on my estate. And a criminal
ಇವೇನೋ
case-
5 ಲಕ್ಷ ಕೊಡ್ತೀನಿ ಅಂತ
affidavit
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ. I filed the affidavit yesterday.
The learned counsel appearing for the petitioner, apart from the legality of the proceedings, apart from the legality of continuance of the proceedings against the petitioner, would again dispose ಮಾಡ್ಬೇಕಾ?
13.1
ಪಾಸ್ಪೋರ್ಟ್ ಕೊಡ್ತಾ ಇಲ್ವಾ?
ಪಾಸ್ಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಮತ್ತೆ
ಮುಂದೆ ಇಂಪೌಂಡ್ ಮಾಡಿದ್ದಾರೆ, ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ.
Lord, if the criminal case goes,
It's
my lord,
quashed then.
by virtue of filing the affidavit.
ಅಂದ್ರೆ ಹೇಳಿ what's the point?
338.
ನೀವು ಕೇಳಿರೋದೇನಿಲ್ಲಿ?
Quashing of
Quash
criminal
ಕೇಳಿದಿರಲ್ಲ.
proceedings.
338 is the offense.
Legal section 34.
13.
What's your defense?
That there's a purchaser of timber who enters into a contract with me, and he engages. He engages a contractor to cut the timber and take it, remove it from my estate. His employee gets injured on my estate.
The petitioner
there's no
is
validity of
before this court calling in question the proceedings in CC 51 of 2022 pending before so and so registered for offences punishable under section 338 of the IPC. They heard so and so. The facts in brief, facts in brief germane are as follows. The petitioner enters into an agreement. Petitioner is a coffee planter. He would want to cut the timber in his plantation. Therefore enters into an alva.
Person agrees to purchase the timber from my coffee.
Who is going to cut it?
He engages a contractor to cut it.
That's
A
all
timber merchant engages a
The
contractor.
petitioner is a planter, enters into an agreement with one MJ Thomas, who for the purpose of the purchase of timber that is available in the plantation of the petitioner. MJ Thomas is said to have engaged labor for the purpose of cutting timber, as he had entered into an agreement for purchase of timber from the plantation of the petitioner. One of the employee injures, one of the employee who was engaged by MJ Thomas gets injured.
Contractor.
One of the employee who was engaged by MJ Thomas's contractor who had been engaged to cut the trees was injured. The injury led to registration of the complaint and CC 51 of 2022 for offense punishable under section 338 of the IPC. The learned counsel appearing for the petitioner submits that the petitioner is in no way responsible for the mishap which led to the injury of yaar is the complainants? Whose injury, sir?
The complainant is the uncle of the injured.
ಇದೆಲ್ಲ ಬಿಡಿ, ಯಾರು ಕಂಪ್ಲೇಂಟ್ ಅಂಕಲ್?
Complainant is the uncle.
The injured family member of the complainant. The issue did not drive the petitioner to this court in the subject petition, inter-alia. The learned counsel for the petitioner submits that passport that was granted to the petitioner is subsequently impounded on the score that pendency of the criminal case in CC 51 of 2022 was not divulged by the petitioner while filing an application seeking renewal of passport. Renewal tane?
Renewal.
Seeking reissuance of passport. Renewal baribadi. Reissuance of passport. In the light of the aforesaid link in the chain of events, i.e. the petitioner being the planter and entering into an agreement with one MJ Thomas for purchase of timber that is available in his plantation, and MJ Thomas engaging a contractor to cut the timber available in cut the timber in the plantation of the petitioner, and an employee of the contractor engaged by one MJ Thomas getting injured, the petitioner cannot be held to be responsible by any act of his that would become negligent and resulting in injury or becoming an ingredient of section 338 of the IPC, permitting further proceedings against this petitioner for no act of his that has led to negligence would become an abuse of the process of the law and result in miscarriage of justice. In the light of the only circumstance that led to impounding of the passport after it was granted, being the pendency of the criminal case in CC 51 of 2022, and that being obliterated by this order, there should be no impediment for issuance of or reissuance of passport in favor of the petitioner or de-impounding of the passport that is now impounded in favor of the petitioner. The learned counsel, learned DSGI Shanti Bhushan would undertake 60 minutes, would undertake that without brooking any delay, the passport of the petitioner would be reissued to him. The submission is placed on record. Application kodbekainar matte? Yes.
I've also filed an affidavit to deposit 5.
The learned counsel on the earlier occasion had undertaken that he would pay 5 lakhs to the family 5 lakhs to the family of the injured victim. The learned counsel has placed on record a memo along with the demand, has filed an affidavit along with the demand draft of
Demand draft I will deposit.
They filed an affidavit that he has paid rupees 5 lakhs to the family of.
Deposit in 8 weeks' time is what I have said. Para number 8, I have said I've deposit within 5 weeks.
Madilva.
Workman's compensation
Passport ಕೊಡ್ಬೇಡಿ ಅಂತ.
ಅಲ್ಲ 19 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀನಿ ಆಗಲೇ ವರ್ಕ್ಮೆನ್ಸ್ ಕಾಂಪನ್ಸೇಷನ್ ಕ್ಲೇಮ್ ಅಲ್ಲಿ. Over and above that 5 lakhs I will deposit purely out of humanitarian consideration.
The learned counsel for the petitioner has filed an affidavit that within 8 weeks from today, he would deposit, he would pay 5 lakhs to the family of the injured. Over and above the deposit that is made before the workman compensations claim or workman compensation tribunal. The affidavit is taken on record.
But I've also mentioned in the affidavit, in the event, my lord, I don't succeed in the MFA, then this 5 lakhs must be adjusted against. Otherwise, it will become, my lord, double whammy for me. I'll pay 19 lakhs plus another 5 lakhs.
Over and above ಅಂತ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು.
ಮತ್ತೆ 24 ಲಕ್ಷ ಆಗುತ್ತೆ.
ಪರವಾಗಿಲ್ಲ. Lantern. Timberly 10%. Yes.
Not in so far as 13, my lord, serial number 13, that is 12978. First petition is concerned, my lord. Those 2 orders which are challenged has to go, my lord.
ಯಾವುದು 1928 in the light ಈಗ ಯಾವ petition line dictation ಕೊಟ್ಟಿದ್ದು ಅದರಲ್ಲೇ ಅಲ್ವಾ
Criminal proceedings are challenged in criminal petition 6038.
ಅದು ಕಾಸ್ಟ್ ಮಾಡಿದ್ದೀನಿ ಈಗ.
That is what, my lord,
in the writ petition line. In the light of the reasons rendered in criminal petition 6038 of 2023, the impugned orders in writ petition 12978 of 2023 stand quashed.
Please, let's
Ordered accordingly.
Great.
This matter I seek a week's time, my lord.
I want to blast complaint, my lords.
2 weeks time ಬೇಕಾ?
1 week.
ಒಂದೇ ಸಾಕ? Learned counsel Ajay Prabhu seeks 10 days time. Objections, huh?
ಇಲ್ಲ.
10 days time to go through the papers and make his submissions. 6th December interim order subsisting will continue till the next date of hearing. Is
Grateful.
Huh?
Grateful.
Attica Gold.
Before my learned friends start, 15.1 become infectious, lordship.
15.1 ಯಾಕೆ?
So that is the petition which is threatening us by writing letter saying that the writ petition is filed, interim order is there.
Lordship.
And
What?
now he said that we can.
I will say that let me complain, lordship. The investigation paper of this case is placed in another case, lordship. And the
ಅದಕ್ಕಾ?
charge sheet is filed.
ಅದಕ್ಕೆ infructious ಆಗಿದೆ.
For that reason.
ಅವರೇ ಹೇಳ್ತಾರೆ
It is placed in writ petition number 27522, lordship, in the case.
All right, the learned counsel Mohammed Tahir submits writ petition 15246. The said writ petition has become infructuous in the light of all the papers being presented in writ petition 23150 of 2024. Therefore, the petition is disposed as having oh, ಅದರಲ್ಲೇ ಅವ್ರು ಇರೋದು.
ಹೌದು.
For that reason,
So ಅವ್ರು ಬೇಡ ಈಗ.
no, now it's not required because it when a remand, we challenge the remand for it. Subsequently, charge sheet filed in some other case. And all the gold, they already have received it also.
No, they
Seven
were not
days.
received.
Who has not received?
State has not recovered the gold because every time when we
Lordship,
issue notice, he has given a reply saying that writ petition is
Lordship.
filed and stay.
It
I'll
is
place
gold.
those letters, my lord. In fact, like last time I gave the letter.
Lordship, kind see page number 35. 27522.
Yeah.
Writ petition number 27522.
ಈಗ ಇದು ಕ್ಲೋಸ್ ಮಾಡದಾ?
Page number 3. Yeah, that can be closed, Lordship.
Lordship may see these letters.
ನೋಡಿ. ಒನ್ 15246 ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಹೇಳಿದಿರ ಇಲ್ಲಿ.
Now it was pending.
ಅದೇ ಈಗ
ಪ್ರಕರಣವು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ವಿಚಾರಣಾ ಹಂತದಲ್ಲಿದೆ. ಕಾರಣ ಮಾನ್ಯ ಆದೇಶದಂತೆ ನಾನು ತಮಗೆ ಸಹಕರಿಸಲು ಬಂದಿರುತ್ತೇವೆ. ರಿಟ್ ಪೆಟಿಷನ್ ನ ಮುಖಪುಟವನ್ನು ಕೋಆಪರೇಟ್ ಮಾಡಕ್ ಬಂದಿದ್ದಾರೆ. ಇನ್ವೆಸ್ಟಿಗೇಷನ್
they said that we will not give any gold.
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
ಕೊಡ್ಲಿಲ್ಲ ಅವರು.
ಈ ಗೋಲ್ಡ್ ಯಾವ್ದ್ರಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ವಾಪಸ್ಸು?
ಎರಡು ಕೇಸಲ್ಲೂ ಕೊಟ್ಟಿಲ್ಲ.
Gold they already received.
Where is the
Kindly says.
he says no gold is given back.
Lord's kind. Writ petition number 27522, Lordship.
ತಾಹಿರ್ ಅವ್ರೆ ಯಾವ್ದ್ರಲ್ಲಾರು ಒಂದ್ರಲ್ಲಿ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಆಗ್ಲೇಬೇಕಲ್ಲ, ಎಲ್ಲದಕ್ಕೂ ಎಸ್ಕೇಪ್ ಆದ್ರೆ ಹೆಂಗೆ?
No, no, I'm not before this honorable court to skip the prosecution, Lordship. I am humble submission that look, gold whatever they are mentioning, they have recovered. Page number 35, Lordship.
ಎಲ್ಲಿ
6.
ನಾಟ್ ರಿಕವರ್ಡ್?
Not recovered, my lord. Your lordship may say notice which we issued to him.
ಫೈಲ್ an affidavit that gold has been, ನೀವೇನ್ ಹಾಕ್ತೀರಾ? ನೀವು
Lordship,
ಹಾಕಿ.
there's one aspect which my learned friend is pointing out. What has happened is, Lordship,
Madam.
gold is sold to us. After 3 months of the incident, they come to us.
ಅಲ್ಲ, that story is there in every case.
No,
ಇದೇ ತಾನೇ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ದು ನೀವು.
not like that. But we most of the time we give the gold. It's not that we don't give the gold. They also aware about it. Several documents are there. Even in this petition, those petitions also, the documents are there where the gold is, we have handed over the golds. In this case, one biscuit was, according to them, it is sold to us. We have not returned. That is their case. It is a case of 7 biscuits.
ಬಿಸ್ಕೆಟ್?
Gold biscuits.
Gold biscuit.
It is stolen by the housemaid and handed over to housemaid's son, and son has given to his friend, and his friend has actually committed did a transaction. After a certain period,
From your house,
yes, no, client's house. So after some time, they gave us a complaint and that give us a requisition that used to return us the gold. So by the time we have already transacted the gold, we don't have a gold with us. We had provided information. In that event, what they're supposed to do? Because now they are saying that 411 will not be we cannot take a shelter of 411 because it is not only about the receive of the stolen property, it's also
Retaining also.
retain.
Yes.
Retain also.
411 is retention of stolen property.
Both what they are saying, I'm not disputing that about the provision, but to kindly appreciate in that event, suppose we are not cooperating, we are not provided even sufficient reply under section 91 notice. So what is the course available for the police is taking a search warrant under section 93. If they take after taking a search warrant, if they search that notified place, in that place, if they found the gold, then they not only can seize the gold, but they also arrest the person who was holding the gold. That procedures don't do. We provide information. We are dealing with more than 3,000 customer every month. In that process, I am admitting that 4 or 5 such kind of people comes, but it is not possible for us to return the gold every time. No, not possible every time. Whenever there is a possibility and small amount, we always used to give a corporate there from our side. We used to give. Even most of the time, they take an alternate gold and present it as original gold. That we are not disputing that. This happens many times. We also always cooperated. But sometime after a long time, they comes and they ask for all those things and they arrest employee without following a procedure. Let them follow the procedure. If they find a gold, let them seize it. If they find anybody who is in that point of time who is in the possession of that particular property.
3 months ವರ್ಗೂ ಯಾರು ಇಟ್ಕೊಂಡಿರ್ತಾರೆ ಅಲ್ಲಿ ಗೋಲ್ಡ್?
That's what is
and you are saying biscuit, who will keep? You are keeping 7 gold biscuits. Huh?
Yes.
7
Really?
gold foreign currency were there. That's all so much
But
things were
that
there.
maid servant, account number 1, was working with me since 23 years. But she was having not a key.
Access to everything.
No, not this Almera.
Only
but
to
not she-
gold biscuit.
Yes, where not these gold biscuits were there. But she is the only lady. But this the maid servant was working with us since 23 years. But because of the trust and confidence, but she was often given the key of the house. And she made use of this locker key also in duplicate, gave it to her son, and he committed theft. Thereafter, it was sold to Attica Gold. But the point is,
Thereafter, it is sold to Attica Gold and the Nimgen Gut.
but the accused one blood voluntarily, he was found, accused number 1 was caught.
Why you did not immediately search?
We have searched, my lord.
No. Instead of getting into assumptions that Attica Gold has taken, it has sold, why don't you search?
No, because of this.
Have you searched in any case?
ಅಲ್ಲ, ಬಿಕಾಸ್ ಆಫ್ ದ ಗೋಲ್ಡ್ ಅವ್ರು ಸರ್ಚ್ ಮಾಡಕ್ ಒಳಗಡೆ ಎಂಟ್ರಿನೂ ಕೊಡಲ್ಲ ಅವರು.
ಕೊಡ್ತಾರೆ, ಯಾಕೆ ಕೊಡಲ್ಲ?
Section 19, they can arrest lordship.
I will record that they will cooperate for the investigation.
Even where search warrants have been issued, they have prevented us from.
Now, you take a search warrant, search the premises. If they don't permit you, then we will pass necessary order.
See the statement.
No, why have you taken a search warrant anytime?
May not be in this case, my lord. In other cases,
And take a search warrant and search.
No, now it is.
Now you can't because
No, your lordship
the
may see-
research
your
matter.
lordship may see the
My
statement.
humble submission is, here we are the employee.
Madam.
The company,
you are
they
the
don't-
employee, I know. Yes.
company, they don't make a queue. They make us a queue. We already
lordship
left
may
the
see the
job also,
statement.
and we are
And
serving.
your lordship may see this affidavit.
ಒಂದು ಕೆಲಸ ಮಾಡಿ ಜಗದೀಶ್ ಸರ್, ಡ್ರಾ ಕಾಂಪ್ರಹೆನ್ಸಿವ್ ಕೇಸ್ ಅಗೇನ್ಸ್ಟ್ ದೆಮ್. ಒಂದರಲ್ಲಿ ಕಂಪನಿ ಮಾಡಲ್ಲ, ಒಂದರಲ್ಲಿ ಎಂಪ್ಲಾಯೀಸ್ ಮಾಡ್ತೀರಾ, ಒಂದರಲ್ಲಿ ಅದ್ಯಾರು ಹೂ ಇಸ್ ದಟ್ ಮ್ಯಾನ್,
Resigned audit director.
ಅದ್ಯಾರನ್ನು ಮಾಡ್ತೀರಾ, ಎಲ್ಲ ಸೇರ್ ಒಂದರಲ್ಲಿ ಮಾಡಿ. ಯಾಕೆ?
But
now-
different incidents, not
ಅಲ್ಲ, now in
they are in the habit of not
ದಟ್ ಇಸ್ ಅ
purchasing
ಡಿಫರೆಂಟ್.
these gold
ನಿಮ್ ಕೇಸ್
biscuits.
ಅಲ್ಲ ಸರ್,
Correct.
ನಿಮ್ ಕೇಸ್ ಅಲ್ಲ. ಇವ್ರು ಏನಾಗಿದೆ, ಎಟಿಕಾ ಗೋಲ್ಡ್ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ 42 ಕೇಸ್ ಕ್ವಾಶ್ ಮಾಡಿದ್ದಾರೆ ಒಂದೇ ದಿನ. ಅದರಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲೂ ಇವ್ರು ಎಲ್ಲದರಲ್ಲೂ they have not bought the legal provision into notice of the court or whatever. Now he says that it should be different. If that is to be different, there should be some material here. Because former director cannot be prosecuted and the coordinate bench has quashed everything. Here Tahir says former director quash ಮಾಡಕ ಇದಲ್ಲ, ಇದು ಎಂಪ್ಲಾಯೀಸ್ ಇದು. ಎಲ್ಲ ಸೇರಿಸಿ ಒಂದು ಕಾಂಪ್ರಹೆನ್ಸಿವ್ ಆಗಿ ಮಾಡಿದ್ರೆ ಸರಿ.
ಅಲ್ಲ, that statement is also false, my lord. I placed an affidavit, election affidavit filed by him.
The election affidavit filed by him. What is the other material you have? Apart from saying
In-
that he is not the director, he is the director.
In the present investigation cases where we have now
ಒಂದು
investigated,
ಕೊಡಿ.
we are doing that, my lord. In fact,
One case you give,
yes, my lord. Now,
then why you do all of these employees now?
no, because your lordship may see this
So,
statement.
Attica Gold ತಾನೆ,
Be given to make.
Attica Gold ತಾನೆ ತಗೊಂಡಿರೋದು.
Correct.
Make the company a party.
No, we'll make the company.
Make
part.
the managing director or director a party. Why don't you do that in
Since
this?
your lordship has disposed this writ petition, now we'll do further investigation.
No,
on this and then bring him.
ಇದ್ರಲ್ಲಿ why you did not bring in the company?
Because of the coordinate, the writ petition 15240 of 246 of
ಅದೇ coordinate
2020.
bench order.
ಅಲ್ಲ, stay. There is a stay in this
ಯಾವ್ದ್ರಲ್ಲಿ stay
petition.
ಇದೆ?
ಈಗ ನಾವು
There is
dispose
no
ಮಾಡಿದ
stay.
ಕೇಸ್ನಲ್ಲಿ.
There is no, I'm sorry to say, in that petition, no stay is there. Which one the lordship has disposed it?
Now you, sir,
15246.
if you draw up an appropriately drawn proceedings, nothing will happen. ನೀವು ಲೂಪ್ ಹೋಲ್ಸ್ ಬಿಡ್ತೀರಾ, ನೀವು ಬೇಕಂತ ಏನೋ ಮಾಡ್ತೀರಾ.
ಅಲ್ಲ, ಈಗ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
ಈಗ ಅದೇನ್ ಮಾಡ್ತೀರಾ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿ. ಇಫ್ ಯು ಹ್ಯಾವ್ ಡೌಟ್ ಆನ್ ಹಿಮ್, ದೆನ್ ಡೂ ಇಟ್ ಇನ್ ಅಕಾರ್ಡೆನ್ಸ್ ವಿತ್ ಲಾ. ಅವ್ರು ಕೋಆಪರೇಟ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೇಳಿ. But 3 months ಆದ್ಮೇಲೆ if you go and search for gold, which person would have kept it?
No,
Sir?
therefore, my lord, your lordship see the
And
statement.
1 minute, how does one come to know that the gold is stolen? What measures have you taken when you receive?
No, that
gold?
is exactly, my lord, I wanted to point
My
out.
let- my let-
File an
this-
affidavit.
We are taking it all this.
What measures have you taken?
What we are saying that.
How do you take gold from people just like that?
No,
50% of the market value they purchase.
Your lordship may see
This
this
all-
affidavit.
5,000 not is
all,
the rate,
incorrect.
3,000 rupees they
It's all
purchase.
incorrect statement, lordship.
Your lordship may see this affidavit. According to this affidavit, they say, this affidavit filed before your lordship, my lord, they
Yes.
Which date, lordship?
they say anything value of 2 lakh rupees and above 2 lakh rupees, they do personal verification.
ಹೌದು.
Now, this is a gold sold at 4 lakh rupees and the amount shown as 3 lakh rupees. We will accept it 3 lakh rupees. Let them show, paper shows that they have done a
Personal
physical
verification
verification.
ಮಾಡಿದ್ರ ಇದನ್ನ?
Lordship, this is
ಈ ಗೋಲ್ಡ್ ಬಿಸ್ಕೆಟ್ ತಗೊಂಡಿದ್ ಪರ್ಸನಲ್ ವೆರಿಫಿಕೇಶನ್ ಮಾಡಿದ್ರ?
certainly in this also investigation, I will produce all the documents,
Produce all
what
the
we have done it. in this
Produce
case
the
also.
personal verification that you have
In this
done
case
and
also.
steps taken.
But and these particularly from 2001, 2021, strictly we are following all the procedures.
You produce what?
This
what
case also
steps-
some inquiry would have done.
ಈ
I will
ಗೋಲ್ಡ್
produce it.
ಬಿಸ್ಕೆಟ್ ವಿಷಯದಲ್ಲಿ ನಿಮಗೆ ಬಂದ ತಕ್ಷಣ ವಾಟ್ ಪರ್ಸನಲ್ ವೆರಿಫಿಕೇಶನ್ ಯು ಡಿಡ್? You
So that we'll
produce
do
it.
that, we'll do that, we'll do
Yes.
that. But in this case also, the accused number one or the concerned accused had not sold the gold. They have sold it, gave it to some friend, and the
If-
friend came and sold the
Now
gold.
we will not dispose this 15246. Next time we will
It is,
dispose it.
I'll leave it on.
We'll
this one.
dispose it next time.
Problems.
You file an affidavit, what steps you have taken once you received this gold biscuit for sale.
In fact, in one of the case, my lord, they had given other intimation saying that they, after receiving the gold, they have sold it. We have gone to those places because ultimately, my lord, that there are some not necessarily financial value, but also has a sentimental value for people because of the history of the gold which they have.
Biscuit sentimental value.
Not for them, but
for
some other
myself.
gold, my lord, where 150-year-old gold was stolen and then not returned to the family. There they sold it, according to him, they sold it to somewhere in Andhra. We have gone there and no such people. And this is what they command. This is the kind of
RBI
letters.
directions are there, less than.
No, I'll place all those.
Less than 2
investigation
lakh
paper if I-
rupees, you cannot receive, you can take a KYC in the respect of whenever you.
I will
are
place all
purchasing
those
the gold.
investigation paper.
Respect of
Place-
purchase.
The lordship can
We
examine
take
that
all the
investigation
KYC
paper.
papers, Lord.
Place everything, sir.
Kindly have it on Tuesday, Lordship.
Or Wednesday, Tuesday ತುಂಬಾ ಇದೆ, Wednesday, yes.
Please.
Next.
16.
The prayer and the writ petition.
Further
Yes,
investigation.
my lords, further investigation.
Reinvestigation or further investigation?
Further investigation. To the CBI is what we have sought for, my lords.
No, I asked the lacuna in investigation
got-
to be pointed out.
I've got it.
Yes.
My lords, petitioner is a doctor and a wife
Ah.
of deceased Srinivasa M, my lords.
Deceased?
Srinivasa M,
All right.
who was a former chairman of Kolar Zilla Panchayat. Now, my lords, the deceased would have a case pertaining to a trap matter against him where he was convicted, my lords. Appeal was filed before this court and he gets acquitted. Now, his acquittal is on 14th September 2023. My lords, he intends being a candidate in the assembly, my lords, assembly elections
Of what year?
of 2023, my lords.
23.
Yes, my lords. He intends, he's one of the candidates and there's a political angle to why he ought not to be standing for that. Anyway, my lords, the fact remains that he intended contesting. There was certain political rivalry and the present incident takes place. Now, the incident that takes place, my lords should notice the incident is on 23/10/2023 between 12:15 PM to 12:30 PM. Now, the informant is one Amarnath, my lords. He is a driver and a mason. He would come to the house of the deceased and deceased would want to know about a construction that's going on. So they travel together. And when they were at a place having tea, my lords, with two other persons, there are two bikes with 6 assailants who come there. In the pretext of greeting them, they take out sickles and various weapons, pepper spray, and they cause the attack. Then, my lords, in view of the other persons coming there, they leave the spot and run away. The informant would go and set the law in motion immediately, my lords, by giving a complaint to the police. Initially, my lords, the jurisdictional police station would commence their investigation. My lords, a lot of dharna took place to say that this matter will have to be investigated by an independent agency in view of the backdrop to this case. Now, what would happen thereafter is, my lords, the matter, though the request was for it to be sent to an independent agency such as CBI, what the state government would do is it would give to the CID. So, my lords, we find that initial part of the investigation was done by the jurisdictional police station. Post that, for about 50 days, my lords, the matter remains with the CID. And as I will demonstrate, nothing much was done by the CID except gathering the material which was done earlier and conducting a test identification parade and laying the charge sheet. Now, my lords,
Investigator.
That's the
Are you-
investigating officer.
Of the 4 investigators, the last one.
Why has he come like this?
He had
CID, my lords, from the
from
CID.
CID.
All right. Let him be seated, yes.
So, my lords, in this whole case, they would ultimately lay a charge sheet against 9 persons, my lords. Now, while laying this charge sheet against 9 persons, the entire motive aspect of it, and in relation to whether there was a political angle to this murder, whether it was a case of Supari killing or not, was never looked into, my lords.
Your allegation was that?
Yes, my lords, throughout. Because, and in fact, my lords, when the CID was investigating this, the petitioner would go and give a further statement pointing out certain suspects, my lords, according to her. There could be a political angle. No investigation takes place on that. Now, my lords, after this entire charge sheet is laid, we are in a position to see that this entire investigation that has taken place is shoddy, my lords. Even the 9 persons who are named with this kind of investigation will probably go scot-free, my lords. The flaws in the investigation, my lords, both of the jurisdictions.
Charge sheet is filed.
Charge sheet filed. Now, the flaws, I have given 2 representations, my lords. One representation given to the Honorable Chief Minister, my lords, and the other which is given to the Home Minister. Despite these representations given where we have sought for this further investigation by CBI, the investigation, so the representations are not considered. That is when I filed the present petition, my lords. Now, the flaws that are there, my lords, I have culled it out, my lords. What are the flaws that have taken place? And both from the jurisdictional police as well as from the CID. This is both. My lords, kindly notice about 23 flaws which we find from the investigation of the jurisdictional police station. My lords, in the very first page, right at the bottom, my lords, the following defects found during the period 23/10/2023 to 29/11/2023.
This
about
is by
5
the
weeks.
jurisdictional police.
Jurisdictional police station. Please notice, my lords, eyewitnesses, my lords, to this incident, CW2, CW3, CW17, their 161 statement gets recorded after 5 days. They throughout there, my lords, 5 days, because my lords, even 1 day delay in a 161 statement, the consequences could be severe. Then, my lords, in the next page, statement of CW4, my lords, he would be absolutely opposite to what we say as a hearsay.
Yes.
A witness, my lords, who in this spur could tell out what has happened. His statement is recorded after 5 days. Then, my lords, the statement under 164 of CW1 and 2 is recorded after 16 days, my lords. Other than CW1 and 2, 164 statements of the other eyewitnesses are not recorded, 2 eyewitnesses. Then, my lords, the point number 4 may not be of that great value because, my lords, when they were being arrested, the indication is they were shot below their knee.
Right.
So on that, there is no material to say why, what, which we don't find anything in the charge sheet. So this is one circumstance which we have put, my lords. And then, my lords, at page number 3, point number 5, please notice this spot mahazar, my lords.
Yes.
Now, you don't even take an FSL team to the spot mahazar in order to ascertain what exactly has happened in this spot. Then, my lords, point number 6, this is at the time of inquest, one of the earliest stages, my lords.
Yes.
Where we normally would see the statement of the eyewitnesses in the inquest proceedings.
Yes.
Now we find, my lords, CWs 1, 2, and 3, their statements are not recorded.
Not recorded at all?
Not recorded, my lords, in the inquest. Then, my lords, point number 7, accused number 4, he was arrested on 24/10/2023. He would say, my lords, that the talwar that he used, he had thrown it in a pond. Now there's no recovery of that also.
Despite the statement.
Despite his statement, they would say there is 10 feet of water, there would be silt. So we have not been able to recover this. This, my lords, I will point out later. This is only aspect with CID recovers later. But later. But kindly notice, my lords, what the nature of investigation that takes place.
Yes.
My lords, I have given the statement and the recovery mahazar page numbers on the right hand side at page 4.
Yes.
Then point number 8, my lords.
When did the CID come into the picture?
I'll give it. It's there, my lords, because my lords would get that at page 10.
Oh,
From 29.
Jurisdictional police.
Jurisdictional. From page 10, 29/11/2023, CID takes it over for about 50 days before they lay the charge sheet.
Yes.
Now, please notice, my lords, it is at serial number 8, page 4. Vehicle is parked. The vehicle which they used, my lords, to come there and commit the offense, that's parked in KSRTC bus stand. Please notice the recovery, my lords. 18/11/2023.
Oh, recovered after a month.
Voluntary statement, please notice, my lords, the voluntary statement was recorded on 24/10/2023. So you take nearly a month to recover on the basis of the voluntary statement. The effect of 27, my lords, you would assume would. Then, my lords, 9, on 2011/2023, the local police held a mahajar at the instance of A2 near the agricultural pond where A2 had thrown the talwar along with A4 and reported as the soil had settled in water 10 feet deep, they could not recover the talwar. Then, my lords, point number 10, the punch witnesses to mahajar held at spot, place of conspiracy, recovery and seizure of one of the murder weapons which has been chosen without opting for anyone to be there. So virtually, my lords, to ensure even we will not be able to prove what is there in the recovery mahajars. Then 11, my lords, unexplained delay of 10 to 20 days for it to be sent property PF forms, my lords, to the magistrate, which ought to be sent immediately. Then 12, the weapons used by the accused persons were 4 in number. The main thing they say is initially pepper spray was used, my lords, and then the assault takes place.
Sorry.
My lords, the case is pepper spray used, then the assault. No attempt to see, my lords, when this was purchased, how it was found, or anything regarding the pepper spray. So that aspect of it also we get an lacuna there, my lords. Then, my lords, 13 at page 6. A5, my lords, his voluntary statement, he points out to the place of conspiracy where they consumed alcohol, where they parked the vehicle, and 2 mobile phones hidden in the vehicle, where they met on the previous day. His voluntary statement is recorded on 27/10/2023, my lords. Mahazars drawn on 10/11/2023. 14 days after his voluntary statement. Then, my lords, CCTV footage of SLV bar, they're supposed to have consumed alcohol there, my lords, before they come for the crime. Nothing, they don't even get any footage of it. Then, my lords, 15, place of conspiracy, we don't get anything, my lords. And what they show is a joint recovery. My lords, as we are on the defense, when it's a joint recovery, my lords, we find a lot of fault why they should have been a joint recovery. Then, my lords, 16, though A8 states of pointing the place of conspiracy where they had consumed alcohol, he has not taken to the places for conducting mahazar. No mahazar drawn for the sequence. Then 17, similarly, my lords, A9. My lords, 18, A1 to 3 were taken into custody from the hospital on 8/11/2023. Recovery mahazars of 2 talwars, 4 empty chili spray bottle boxes. Place of conspiracy at graveyard, spot mahazar was held on 17/11. So, my lords, 8/11 you come to know of it. You wait for 11 days and do it. Similarly, my lords, 24/10 A7, recovery takes place 5 days thereafter at 19, my lords. 20, the talwar was sent to the FSL on 4/11/2023. Sorry, that was seized on 29/10, my lords. There's a 5-day delay. But 21, clothes of accused persons have not been seized. Next, my lords, 22, even they don't, the jurisdictional police even don't do a test identification parade, my lords. And 23, recovery mahazars of 2 bikes held on 18/11. Though, my lords, 8/11 they're in custody. My lords, this is in so far as a jurisdictional police. Then, my lords, because of dharnas that took place, my lords, the matter goes to the CID. Please notice next page, my lords, CID investigation. For about 50 days they investigate. They hold the test identification after 45 days, my lords. CID. My lords has gone through the whole thing.
Yes, sir.
I've shown the flaws of CID, my lords. And then, my lords, after these flaws, most important aspect will be, my lords. Now, if it is a case of Supari killing, my lords, the prime evidence to this will be the phone conversations that have taken place by the person.
CDRs not taken.
CDRs, that's by virtue of an order by this court, my lords, because otherwise we'd have not even got the CDRs. Now they've obtained CDRs. That is one aspect of it.
Now, 9 months agide charge sheet haki.
How?
What is the progress?
Nothing. Only my representations which have gone, which have not been considered. My lords, if my lords just for a minute.
Over. Charge sheet has been filed. with
Sheet
the
is filed.
Honorable Court. Now further investigation is being done. On the
Who ordered further investigation? ನೀವೇ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಅಲ್ಲ, 173(8) on your own you're doing?
With the permission.
Permission,
My
of
lords,
course.
permission was granted by your lordship on the last occasion that call details should be collected by the investigator by the 30th of
So
last.
pursuant to that, the call details are taken now.
No, that was confined only to collecting of the call details, not further. But they are doing it on their own with the aid of section 173 subsection 8.
CBI is a party here.
Yes, my lords.
Yes.
My lords, if my lords should now notice page 13 for a minute, my lords, I've shown the common lapses.
Yes, I have seen.
Between both the teams. And then, my lords, most important I find is scientific evidence 0, my lords. And if it's a case of Supari killing, my lords, with a political rivalry, minimum that is expected is, my lords, an investigation in that angle. Now you don't do any investigation at all in that angle. And then, my lords, kindly I've put the reasons seeking for further investigation at page 16, my lords. One is all these lacunae, galore,
Yes.
my lords has observed it in the case of Manjula, my lords, where my lords has probably traced all the cases where investigation has been given to the CBI, though it could be in rare circumstances, but where the court feels there's absolute lacunae. In
your case, in one case I wrote 9-fold lacunae.
Yes, my lords, that was another case where further investigation to a different agency.
CBI alva.
Illa, CBI ಗೆ ಹೋಗಿಲ್ಲ. To another agency, my lords. We put the 9-fold to another agency, not to CBI. So in 16, my lords, I have pointed out exactly in this case, my lords. One is lacunae galore, my lords. Second, investigation would not inspire confidence with all these lapses. Third, my lords, it's a lopsided investigation, unsatisfactory, shoddy. Then, my lords, no investigation done to ascertain the actual motive of murder as regard political rivalry. My lords, fifth, no investigation to ascertain the main conspirators and whether it was an act of Supari killing. Sixth, my lords, further statement given to the CID, which does not form part of the charge sheet. The suspects who I named, nothing done in that regard.
But 302 is the offense now.
How, my lords, but persons who have really done this, who have got this done.
Those are not identified.
Most important, my lords. My lords, probably in all Supari killing, we would find certain assailants and the main conspirator who gets it done. Here, we don't even have an investigation towards that end. And a person who wanted to contest the elections and who was able to contest, wanting to contest is because he got an acquittal in that trap case. Only after that, my lords, he could have contested. So there's a political angle where people didn't want him to contest. And then, my lords, my representations which I have given to the Chief Minister and Home Minister, disclosing all this, asking reasons why it can't be given to the CBI. Nothing, my lords, no replies to it at all, not considered. Then, my lords, if there is going to be any further delay, my lords, then no witness will come forward to give statement, my lords. Even what little evidence that can be collected as scientific evidence could disappear. CDR, fortunately, by the order of this court, we are safeguarded, my lords. There might be other forensic evidence linking the so-called, who we think are the main persons behind this act, that will get destroyed. So, my lords, insofar as the law on the point, my lords had considered in Banjula's case in 2022, all the various judgments, my lords, right from 2010, my lords.
Subsequent to that, there are many.
After that, two important judgments, Supreme Court, my lords, where they have referred it to the CBI.
This is Pardiwala report.
My lords, Manjula's judgment.
That stayed by Supreme Court.
It was stayed and it had come up last on 11/11 and it's given as 14/11 just as a tentative date, my lords, Manjula's judgment. So further investigation could not take place on the basis of this. However, my lords,
This is stayed, I know.
however, in this judgment, my lords had touched upon all the previous decisions, mainly, my lords, three decisions. State of West Bengal versus Committee for Protection of Rights. That is
2010.
one of the standard judgments,
Yes.
my lords. 2010 Constitution Bench.
In all CBI cases.
Yes, my lords. Then
Reference.
Pooja Paul, 2016. And then, my lords,
Dharampal.
Dr. Naresh Kumar, 2020.
Yes.
So we have all the judgments up to 2022 in this, my lords. After which 2 judgments of the Supreme Court is in this compilation, which I've just given now, my lords. My lords, page. In that we put all the compilation, but only 2 subsequent to my lord's decision. The page nation is in the bottom, my lords, page 37.
Which are the 2 judgments?
My lords, the first is,
They have stopped at Pooja Pal, Dharampal, Pooja Pal.
I'm sorry, Pooja Paul, which my lords,
Allah,
Rajesh was the last one.
No,
my
you
lords. Dr.
you have
Rajesh
stopped
was,
here at Pooja Pal. ಅದಾದ್ಮೇಲೆ ಇದೆ.
ಅದಾದ್ಮೇಲೆ 2024 page 37 ಅಲ್ಲಿ, my lords.
ಇಲ್ಲೇನು ಸಿನಾಪ್ಸಿಸ್ ಇದ್ರಲ್ಲಿ ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ ಇಲ್ಲ?
Bottom ಇದೆ, my lord. Page nation bottom ಅಲ್ಲಿ ಇದೆ. 37 may be noticed, my lords.
ಅಲ್ಲ,
2020
ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ stops at 15, serial number 15.
No, my lords, in between, we have these 2 judgments of 2024, which we get at serial numbers 2 and 3, my lords. 2 and 3.
ಅದು ಹಳೇದು ಕೊಟ್ಟಿದ್ದೀರಾ?
In the index, my lords.
ಏನು ಇಲ್ಲ ಇಲ್ಲಿ. 24 ಯಾವುದು ಇಲ್ಲ. ಪೂಜಾ ಪಾಲಕ್ ಸ್ಟಾಪ್ ಆಗಿದೆ.
ಅಲ್ಲ, my lords, ಅವ್ರು ಹಾಕಿದ್ರಲ್ಲಿ they put Pooja Paul at
That is the last
my lord, they put it at serial number 15, but 24 though serial number 2 and 3 ಅಲ್ಲಿ ಇದೆ.
ಇದೆಯಾ ನೋಡಿ? I am sorry, I am not.
2 and 3, yeah.
ಇದೆಯಾ?
ಇದೆ. 2 and 3, serial number 2 and 3.
ಅದನ್ನ ಫಸ್ಟ್ ಅದನ್ನ ಹಾಕ್ಬಿಟ್ಟು ಇದನ್ನ
Normally, those 2. My lords should kindly now notice page 37, my lords.
All right.
Page 37. My lords, this was a case of 302, which was being investigated by the crime branch, my lords. Page 37. It was being investigated by the crime branch. Not being satisfied in the High Court, my lords, a petition was filed seeking for a CBI investigation.
Yes.
That petition was dismissed. Matter goes up to the Supreme Court. Supreme Court allows it, my lords, and then would direct the CBI to investigate. My lords, here reliance again on 2010 State of West Bengal, 2013 Bharati Taman, 2004 Zahina, these 3 judgments.
Yes.
Then the next judgment, my lords, should get at page 42, 2024 SCC online, SC 2448, Mandakini Diwar versus High Court of Chhattisgarh. Page 42.
Yes.
Here, my lords, a UDR ends up with a closure report. Then High Court, when we go to High Court to deny it, Supreme Court grants an order for CBI to investigate the matter. This should be the latest of the decisions, my lords. All the others, only the, my lords, it's a fit case, my lords, with all these aspects for further investigation.
Representation to the Chief Minister, other state.
You will consider that and pass orders.
My lords, one, sorry. This
State
one.
head of the corporate party.
State is not a party here.
Investigation officer.
No, no.
But
Special public
special
prosecutor ಇದ್ದಾರಾ?
prosecutors,
SPP ಇದ್ರ.
my lords, one,
He is appointed by the state. Yes.
before the learned senior stats, my lords, one important aspect, accused, my lords, would give consent for polygraphy. Polygraphy is not done.
Gives consent also.
Consent.
My lord, as far the prosecution is concerned, I'm in a very serious dilemma. I wish to
Hand
muster,
it over to the CBI.
I wish to muster courage before my lord to be very, very candid,
Yes, sir.
frank, outspoken.
Yes, sir.
I will look at it, I am also special public prosecutor for conducting of this case before the Sessions Court in Kolar.
Yes.
Another special public prosecutor is provided to assist me. But I have scrupulously gone through the charge sheet. I have scrupulously gone through the 8 petitions that have been addressed to the government of Karnataka, who including of Chief Minister, Home Minister, from time to time by the wife of the deceased. Deceased was a politician. Well, he was a leading politician in Kolar district. He was municipal councillor, he was district panchayat chairman, it's an aspirant for the last Lok Sabha election. By then, he was done away with. By that time he was done away with, his wife as a medical officer had put in 27 years of service in the Karnataka medical department.
The petitioner?
Well, yes, this is his wife. She resigned from the job. She developed so much of indignation at the investigation that was going on, at the kind of the investigation that was being conducted by the local investigator. She resigned from the job, took up the cause on behalf of her husband. She, from day one, she wanted the investigation to be done by the CBI. Consistent. She has been very consistent in her appeal to the government. Well, she made it known in her petition to the government, there is involvement of bigwigs in this case, local politicians in this case. Because accused number 1 is a mason. Rest of them are his followers. There are laborers.
ಅವ್ರನ್ನ ಅಕ್ಯೂಸ್ ಮಾಡಿದಾರ?
ಅವ್ರನ್ನ ಅಕ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. No, I don't dispute their involvement. They physically participated, but at the instance of someone.
He lies elsewhere.
At the instance of some influential person who has taken care of all this. Well, I would now come to the point, relevant point. There are 20 remand applications filed into the Honorable Special Court. 20 remand applications from time to time till the first charge sheet came to be filed into the Honorable Court. 20. Now, well, in none of the, as my Lord knows, it may be needless for me to submit, whenever there is a remand application made, investigating officer is expected to produce the CD for the inspection of the court to take a decision as to what period he should be handed over.
Not produced.
Yes. On no occasion it has been produced. CDs have not been produced on all the 20 occasions. Now there are 4 investigators. But the one who is before the Honorable Court, his investigation lasted in the case only 8 days.
Alright.
He did one. By then they had done away with everything. There was nothing for this investigator to do. I got the case file from him, sat with him, had a threadbare discussion of the case from A to Z. I have been able to realize, my Lord, investigation was done by the local police officer for 37 days. Rest of the days, till the 90th day, it was done by the CID. Well, the local police officer had nipped in the bud all the material circumstances that were emerging from time to time. My learned friend submitted, he failed to record the statement of eyewitnesses for 5 days. Well, the complaint discloses of the names of eyewitnesses and also rest J witnesses.
Yes.
Rest J witnesses. They would, within no time, they would tell others of what has happened.
But that is also recorded after 5 days.
Yes, 5 days. 5 days. They were there. They were very much there in the locality. They were easily available to the investigator. He was not prepared to, mentally was not inclined to. Why? What was making him not to care for recording the statement of these witnesses who were very much there under his nose, round the clock? I have not been able to explain. I have found it in the investigation. Well, A1, 2, 3 were arrested on the very date of the incident. Police officers went to arrest them. They resisted the arrest. 1 to 3 resisted the arrest. They contested the arrest. In fact, they resisted and they were about to pounce upon the police officers, other subordinate officers, not the investigating officer. He had deputed his men to cause the arrest of them. They were resisted by A1 to 3. They had to open fire to get hold of them. They opened fire, got hold of A1 to 3.
That's where the knees are injured.
Yes, they got, my lord, police later, after they were not arrested, they were apprehended, taken to an hospital, hospitalized. then investigating officer, first investigating officer would come to scene at that stage. Well, they were quite ill and healthy. Nothing prevented, nothing precluded the investigating officer, local investigating
To arrest
officer
them.
from taking them into,
Custody.
from causing their arrest. You would not cause their arrest till then, till when? Well, till the apprehension on 23/10/2023, apprehension, they were arrested by the IO on 8/11. After 2 weeks, he would cause their arrest. Who were taking care of those inpatients? No one, no witness. Was they not under his surveillance? They were very much under his surveillance. Would not surveillance tantamount to custody? It would tantamount to custody. Then he would make application. Then he would proceed to record their statement, voluntary statement, after causing of their arrest on 8/11/23. What would he do? Well, that recovery was disclosed. They disclosed of so many things. They made it known to the investigator. They had kept such and such thing, talwars, choppers used for melody. He had sustained 40 injuries. Of them, 17 were chop wounds. 11 were incised wounds. Rest, lacerated wounds, etc. 40 wounds he had suffered, the deceased person. They disclosed everything to him. Well, whenever an accused volunteered statement, showing of his willingness, displaying of his willingness to lead the police right away to the place where recovery can take place, was it not bound upon him to start immediately? My lord, for 10 days he would not go. After 10 days, he would take them to the place. No, he would get led to the place. Recovery takes place. Recovery in all cases. Whenever accused were arrested, their statements were recorded. I'm now making a general submission before Your Honor, my lord, touching all the accused persons. Everyone was arrested. On the date of arrest, voluntary statements were recorded, but no recovery, even on the following day, second day, third day. He would take them for recovery after a week, in some cases after 8 days, some cases after 10 days, some cases after 11 days. What is that? My lord is now, what is that my lord is now able to infer from the conduct of this witness? Was he not being pressurized, my lord? Had there been, my lord, every person is guilty of all the good he did not do. That is the famous saying. That is the popular saying. Investigating officer should not, he should not sit at the top of law. Investigating officer always his role is always of serious consequences. Investigating officer should follow realities and law. Well, these are the guidelines as to the investigation. He is the best judge of investigation. When it goes before the court, it is a different thing. Now, my lord, his investigation is full of blunders. There can't be any excuse. I'm not prepared to be one with this investigation at any stage. My lord, murder is a heinous offense. One of the heinous offenses. Heinous offenses, only police officer of the rank of circle inspector alone can conduct investigation.
Now, who is the first time?
He would allow sub-inspector of police to conduct investigation. A part of the investigation during his time has been conducted by sub-inspector of police. How dare he get that done by a sub-inspector of police? How could he delegate?
That is why it is so shoddy.
Now, Miller, that is now. Nextly, in all the cases, recovery would take place 8 to 11 days after recording of voluntary statements. No law, it should, then PF is prepared to retain the properties for the purpose of investigation. He needs the sanction of the court. He needs the permission of the court. Otherwise, it would be in the illegal custody of the investigator. My lord, he would send property forms to the jurisdiction court seeking permission to retain those properties with him in his custody for conducting the rest of the investigation. How dare he do that in the eye of law? Law is staring at him. Don't do this. You are going to be in illegal custody of the properties. Well, he would send property forms seeking permission of the jurisdiction court after 17 days. In some cases, after 14 days, all of them from 14 days to 17 days. Well, no part of this investigation is proper and legal. It is tainted. Yes, it is tainted. If my lord wishes me to make submission, it becomes more and more painful for me to read it because it is far from satisfactory. And why have they done it? What is in it? Then it went to the CID. CID, first investigator was in charge of it for 50 days. He would do nothing. Last, this police officer would come. He would strive, I have seen the records, he would strive to do something, but he was not able to make good.
Because everything had already been done.
Yes. Now, my lord, as special public prosecutor, government has reposed this confidence in me to defend the prosecution, to defend these unfortunate, these investigators. It is very painful thing for me. I can't afford to defend these investigators because they have been never true to the work they have taken at the time of getting into the police service. They have betrayed the cause of justice in carrying out such investigation at the instance of someone. All that I'm anxious to submit at the end before my lord is, there is someone playing its role behind the screen. He is still at large. He is still absconding. Well, I only wish if the investigation can be handed over to the agency like CBI, that unknown person, that person who is behind the screen may be brought to the front or may be brought to the central stage. With this, I submit before my lord that I have nothing to oppose him. I have everything to add to what he has submitted. Therefore, I request, leaving the rest of the things for your lord's kind inferences, I would stop my submission.
Yes. Kotre ಮಾಡ್ತೀರಾ? ಇಲ್ಲ.
One aspect I may just add.
So he has not refuted anything.
No, one aspect I wanted to add. 30th December 2023, my lords, the 9 accused, they gave their consent for polygraphy. It has not been done. Now, my lords, now A8 and A9 have filed their application seeking bail. So, my lords,
Who has filed?
A8 and A9, all are in custody. When in custody, they gave their consent for polygraphy. Now, my lord, since nothing was done, they have sought for their release on bail, my
They're
lords.
released already?
No, they're not released. They're not released. But my lords, as it stands now, my lords, the way it is, if they're going to be coming out on bail, polygraphy may not even happen. Which consent they had given.
We'll see. Heard, deserved. Rarely seen a very candid public prosecutor saying what is true.
Only the first case.
It's only if the person of that stature can do it. Yes. Thank you. Sir.
Yes, obliged.
Had reserved.
70.
Lordship, for the respondent, your lordship.
When we have the petition.
Lordship, copy is not yet served on us, your lordship.
Eh?
Copy in the serve. Copy.
Where are you?
VC, your lordship.
Oh, you're there.
Please.
Yes. Copy kudi.
Sorry.
Petitioner to serve set of papers upon counsel Shri B.B. Patil. List the matter. 7 ಏನಿದೆ?
No, this is bank guarantee, release of bank guarantee.
Release of bank, then list on 27th. Yes. ಇವತ್ತೇ ಕೊಡಿ copy.
Please.
Orders. 80.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಕೌನ್ಸಿಲ್ ಇದು ಮಾಡಕ್ಕೆ ಸರ್ವ್ ಮಾಡಕ್ಕೆ ಡೈರೆಕ್ಷನ್.
Emergent notice to the respondent. Next. ಆಗಿದೆಯಾ? ಸರಿ ಬಿಡಿ. List immediately after service of notice upon the respondent. Next.
Interim order may be extended.
Yes, next.
Interim order.
Extend ಆಗುತ್ತೆ.
19.
Yes.
19, 20 and 21, I'll take notice for de facto complainants also.
Learned HCGP accepts notice for The de facto complainant in all these cases registry to print the name of HCGP as appearing for the second respondent complainant as well. Therefore, the service of notice stands complete post the interim order there.
Please, my lords.
Post the matter in admission, interim order subsisting shall continue to the next date of hearing. Next.
22.
Special court matter.
That anticipatory bail, my lords,
Anticipatory bail?
for accused number 8, my lords.
What anticipatory bail?
My lords, this is that Bagair Hukum, my lords should recollect 482, my lords had rejected.
Bagair Kanun.
Bagair Khanna, that's
Yes,
the.
Bagair Hukum committee had.
Bagair. My lords, the
Yes, sir.
allegations that are there, my lords, all this stems from the private complaint as my
All
lords
right,
had seen.
but why anticipatory bail is rejected?
No, lower court have rejected, and what I find strange is, my lords, the offences against me, 409 doesn't come against me. I'm not a public servant. I don't come under any of these categories mentioned in 409. So, my lords, the offences against me are offences punishable with less than 7 years. Now, if it's offenses,
Let him take notice.
Being a member of
they've taken
committee,
notice.
I don't understand.
Sir, I have myself written the judgment.
How to?
All of you were hand in glove, cohorts in crime.
Investigation, yes, my lords, but for the purposes of bail and anticipatory bail for an offence which is less than 7 years, and if the, my lords, if the.
Let him take notice. All notice agide already.
ತಗೊಂಡಿದ್ದಾರೆ madam. Last time ತಗೊಂಡು.
Anticipatory bail.
Anticipatory
And where
bail.
are you?
My lords, Tahsildar has been granted anticipatory bail. My lords, AC's report points out towards the Tahsildar.
Tahsildare ಮಾಡಿರೋ, it's come for quashing before me.
Yes, my lords.
Tahsildare ಮಾಡಿರೋದೆಲ್ಲ.
So Tahsildar has been granted anticipatory bail, my lords. I have produced it.
How was he granted? Yes, Jagdish. Everything is done by Tahsildar.
Yes, my lords. That's a report also.
Creation of records, manipulation of records.
And the petitioner is a practicing advocate who was part of the committee for a certain period of time, my lords. And my lords, the allegation is probably, my lords, they say the chairman. But
Against
these
the
were
chairman.
all part of that committee, my lords.
Yes, look into it. Wednesday, fresh matters. We'll pass orders on that day. You notice ತಗೊಂಡಿದ್ದೀರಾ already. It's a bail matter. Yes. List on Wednesday in the fresh matters list.
Lovely.
Yes, next.
23.
ಏನಿದೆಲ್ಲ? 23 bail.
Like,
Same
for the
identical
petitioner in this
matter.
case.
Where is that?
Connected matters is on 22nd of this week.
List on 22nd.
Interim orders that.
Interim order subsisting will continue to the next date of hearing.
Watch out.
Page 24.
This is the case.
CBI.
CAD.
Ah.
The case where the amount, my lord, which was in the account of the petitioner, which was not subjected to, my lord,
Oh, this I passed a detailed order.
I've seen the order, but I'll take instructions not from the.
As to why without hearing the petitioner.
ಅವ್ರಿಗೆ hearing ಕೊಡದೆ ಅದನ್ನ ಒಂದು ಅಕೌಂಟ್ ಇನ್ನೊಂದು ಅಕೌಂಟ್ ಟ್ರಾನ್ಸ್ಫರ್
ಈಗ safe ಆಗಿದೆಯಾ ಅದು?
It's not.
All right, let him file his objections or take instruction. The learned counsel P. Prasanna Kumar, representing the first response, CID, na?
CID.
Representing the first respondent, Crime Investigation Department, the CID of the state, seeks 10 days' time to go through the papers, file his objections, or make submissions as the case would be. List the matter on 5th December.
Please.
5th December. Yes.
Interim order maybe.
Interim order, yeah. Interim order subsisting shall
Not to-
continue to the next date of hearing.
He's offshoot of, my lord, Shriki.
Oh, Shriki offshoot. So the key lies there. Yes.
Deeply obliged.
Yes.
This is
Get to file objections in this matter.
at least I may be
What has
permitted
got
to
Gautam-
open my notes.
What has
I have a very
what
good
Gautam
strike
here?
rate here that I've a negative strike rate
Oh.
of a first ball dismissal.
No, no,
At
no.
least let me open.
What is, I was thinking, what has brought Gautam here in the same case?
Same case. This is accused number 2, my lords.
This is
Ah,
the
the
wife.
Yes, sir.
My lord, what has happened in this case?
Wife of Sandeep Gurraj.
Wife of Sandeep Gurraj. my
Yes.
lord. Now, my lords, the crime came to be registered in December of 2018. My lords may bear with me
Illen
for
challenge ಮಾಡಿರೋದು ಈಗ?
2 minutes, my lord.
Take. No issue.
December
2018, the crime comes to be registered. My lords, 3 supplementary charge sheets filed, the last being in 22. Till now today, my lords, trial has not commenced. I have appeared over 150 times before the trial court. Now, my lords, I seek relaxation of bail condition.
Make,
My lords,
no,
just a minute.
you want to travel to
No, my
Dubai?
lords, not, my lords, my problem is this, my lords. If my lords may kindly have page 189.
I'm
189.
looking at your prayer, sir.
Yes, my lords. Now my son, I need to travel for my son's medical treatment. My son's passport has expired. Now, my lords, my travel is scheduled for 25th. I even booked return ticket. Now, my lords, I'm only seeking, let the matter be kept next week. In the meantime, my lords, let my passport be released so that I can apply for my son's passport. Now, my lords, if my lords may kindly see.
Where is your passport?
My lords, my passport is in custody.
Whose custody?
Trial court's custody.
That is by the order of the Supreme Court.
No.
Yeah?
That was in A1. That is where my lord said you have to go to the Supreme Court. I've gone to the Supreme Court, matters listed on the 18th.
All right.
Now, my lord, so far as the wife is concerned, my lords may kindly have page 124. At 125, 3. This is a condition of bail. They shall surrender the original passports to the jurisdictional court. My lord, at 125, my lord says this.
Oh, bail by this court.
Bail by this court.
All right.
125, my lords, I have surrendered my passport. Thereafter, my lords, I sought modification. My lords, the modification was rejected by this court, saying that you go back to the court because you're seeking limited permission of 10 days to travel. Now, my lords, kindly see, my real difficulty is this. If my lords may kindly have 189 and 192, 2 pages. 189, my lords, is the letter from the center there, where my son is going for treatment. Now, my lords, may kindly see page 192. My son's passport has expired on 2/7/2020. Now, my lords, I need at least few days to renew that passport and to show my bona fides, my lords, at 199. My lords, to show my bona fides.
Yes, sir.
I've even booked my return ticket. Kindly see 202. I've booked my return ticket. Paid the entire money, booked my return ticket.
Will permit travel?
No, Millards, what
Where?
has been sought here is virtually seeking review of a coordinate benches order. My lords may
I'll
note.
show that. my
Just,
lords.
I'll just
One
point.
minute, Justice B.A. Patil or order.
How, and then it went before His Lordship Justice Vishwajit Shetty.
Where
I'll
is
just
that?
point out where they sought for the same prayer.
156.
One nimsha.
No. My lords, 150, I'll complete that, my lords. 156. My lords may see 156. My lords, because I sought for relaxation of the bail condition. My lords, at 156, kindly see what the Honorable Court says. At 158, if the petitioner intends to travel for limited purpose on medical grounds, she is required to file necessary application before trial court for the reasons stated in the impugned petition so and so cannot be modified or relaxed permanently. It is brought to notice that the accused number 1, who is the husband, has already filed similar application. No, I filed that order. I have challenged before your lordships today.
You should go there on.
No, my lords, kindly see. I have challenged that order at page 178. That order came to be rejected at 11.
No, sir. But you should bring that to the notice of the coordinate bench, which had
Against that, 482 only would lie. And my lords, now today there is a notification that all 482s come only before your lordships. Today, where do I go, my lords? I'm in this ping pong. I can't go anywhere.
Best is next flight to Delhi.
Very well, my lords, and my lords may dismiss it. I'll go there. If that's because I have a great strike rate, I'll go there. Very well, my lords.
Yes, sir.
What more can I add, my lords?
Very
They're
well.
willing to go there.
No,
I have very
hey,
little
in the
to add.
lighter way, he's.
My lords.
Why, sir?
Virtually, we're seeking review of a coordinate benches order, which is
I'm
not
only on this,
permissible.
Gautam.
Let's see 170.
1 minute, Gautam. It comes before 482 bench is all right, but now Justice Vishwajit Shetty has passed an order on 15th October.
Yes, ma'am.
2024.
16th, I filed my application.
All right, I'm not saying you're not followed that. Now the offshoot of that order is the present petition. Let the matter be placed before the same honorable judge.
I have no.
Yes, then will be directed to be posted tomorrow.
Very well.
Yes.
Very
The petitioner is before this court calling in question an order dated 11/11/2024 passed in CC 7559 of 2019 by the third additional third ACJM. The order is an offshoot. Order is pursuant to an order passed by the coordinate bench in criminal petition 10133 of 2024 disposed on 15th October 2024, wherein the coordinate bench had permitted the petitioner to file an application before the concerned court concerned court seeking permission to travel. Adenadu? Permission to travel, is it? Permission to travel. That application has been rejected. Therefore, the registry to place the matter.
It was disposed of with the direction that the trial court considers the application. Trial court rejected it.
The trial, that's good. Trial court, the concerned court has now rejected the application seeking permission to travel. In that light, the registry to place the matter before the same honorable judge, Honorable Justice so and so. The learned counsel pleads grave urgency. The registry is directed to place the matter before the honorable judge tomorrow.
Grateful.
If he says no, let it go before it, then we'll take it.
Great.
Anyway, you are used to this ping pong.
When I come back here at 2:30.
Then move it at 2:30, I'll take it.
I'll serve and I'll inform them.
All right, yes.
That is why I made a statement. I made a sufficient state should be passed. I also not seen the subsequent.
Sorry, yes.
Thoughts in this matter.
Withdrawal.
The matter in the trial court is disposed of, my lord. So this petition becomes.
Yesterday it was disposed of despite the fact I filed a memo saying matter is today.
Disposed of by what?
By acquitting the accused. I pleaded with the court below, please keep it today, 24 hours. Lords, the matter had come up before the coordinate bench. The coordinate bench said there is a circular. As per the circular, the matter has to go before the regular court, which passed the earlier order, my lords. Under the earlier order, this court had granted 8 weeks' time for me to produce the orders of the division bench, the contempt court orders.
Right, but now there is an order of acquittal.
My lords, the only thing is, my lords, I pleaded, my lords, now this petition was filed in 2020.
No, true, sir, but
from 2020, my lord, he was not able to obtain a stay order. When the matter was posted, when the matter was posted for judgment, when the matter was posted for judgment twice, my lord.
I understand, my lords.
Today there is a judicial order of acquittal, and if there is an order of acquittal, remedy lies elsewhere. Or to Baralwala.
My lords, I agree, my lords. I'm only bringing it
No,
to the
true. The court should have awaited, but there is no stay here.
Two facts, my lords, I'll place it before the court. The matter came up on another criminal petition last month. This court directed the trial court to mark these documents and dispose it off within 8 weeks. 8 weeks expires only in December 2018.
If not earlier.
If not earlier. My lords, the only thing is, my lords, we said you still have time. Give me 24 hours. My lords, the matter was directed to be listed before this court on 11th.
But order is passed already.
Order is passed.
1 minute, sir.
Yes.
You tell me. Yes, Samuel.
Lords, my only
acquittal
thing is,
ಆಗೋಗಿದೆಯಲ್ಲ.
no, my only thing is the trial judge should have waited for 20.
No, he has not waited.
Correct.
He has passed an order. Now what's to be done? Tell me.
Lords, the issue here is, I was not even heard in the matter. Because I said my petition
You
is
can
pending.
urge that in an appellate
Government of
forum.
Karnataka.
Lords, should I go through the rigmarole of another?
Absolutely, sir. That's the procedure that is prescribed under 482. Can I set aside a conviction order?
No, no, Lords.
Sorry, acquittal
No,
order.
sorry, an acquittal order. Lords,
Acquittal
I'm-
order.
I'm for a minute, I'm only saying,
Yes.
this court's order was that 8 weeks' time.
True.
I brought out this matter.
See,
I had also
eight
disclosed.
weeks, if not earlier, there is no interim order here.
No, my lords,
Court
in
has
respect
proceeded.
of this particular case, this is an independent case I had referred to in that particular criminal petition. But unfortunately, since the portfolio judge was different, it went before the portfolio judge. On 30th, I argued the matter. Then the court said, place it before the judge before whom the earlier order came to be passed.
And 30th,
Lords, just one
court
minute,
was
sir.
not inclined to give stay also. On
that's
earlier
okay.
occasion,
Lords,
four
because-
coordinated
No, no.
benches, my lord, he has argued, he has not, from 2020, my lord, no stay is obtained.
Sir, Joshua, sir. Now, right or wrong, there is an order of acquittal.
Very well.
There is a procedure to be followed after the order of acquittal.
I will
The order of
wait, Lords,
acquittal is
Lords, I only-
pronounced. I cannot now say, if
No,
there
it
is an
cannot-
no, if there is an interim order and then he has passed an order, then it's.
I
okay.
agree, my lords. My only concern is, this is a Parsi symmetry. And what has happened is,
No, facts may be, sir. That's a different thing. There is an order of acquittal. You challenge the order of acquittal.
I'll have to do it, my lords. There's no other way out.
Yes. Heard the learned counsel so and so. The learned counsel Arvind Babu representing the respondent would submit that the concerned court has passed an order of acquittal in favor of the respondent. A second respondent by its judgment dated. Yes.
13/11/24.
13/11/24.
I also filed a memo.
13/11/24. The council has filed a memo to that effect. In that light, the subject petition is rendered infructuous and the petitioner is at liberty to challenge the order of the concerned court acquitting the second respondent in a manner known to law, ordered accordingly.
Great.
Thank you.
Sir, you are appointed.
I've gone through that, my lord.
Matte, sir.
It is not properly worded. Well, the emphasis should be laid on what is stated here in the early part of the sentence, first part of the
No,
sentence.
true, that's an order. Then how can we?
Hanumantarai advocate is hereby appointed as special public prosecutor to appear before the Honorable High Court of Karnataka, Bangalore.
High Court of Karnataka ಅಂತಿದೆಯಾ ಅಲ್ಲಿ?
It should have been over there. On behalf of Dr. S. Chandrakala for conducting cases, etc., etc. This notification is issued as per the private request received from Dr. S. Chandrakala. At her instance, this order was passed. It is not properly worded, Swami. It is not well worded.
How do we take that now?
I may be taken as the prosecutor for the complainant before police, or
Should we implead the state?
ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ, ಕವರ್ನು ಮಾಡ್ಬೋದು.
So you need to be heard?
ಮಾಡ್ಬೋದು.
All right.
That
ಅದರಲ್ಲಿ ಕವ್ಯ ರಿಸರ್ವ್ ಆಗಿರೋದು. Then we will not reserve it. Further hearing ಮಾಡ್ತೀನಿ.
it may be had for further hearing on Tuesday, my lord.
ಅಷ್ಟು ಜಲ್ದಿ ಆಗುತ್ತಾ ನಿಮ್ಗೆ? Friday. Next Friday, sir. ಅವತ್ತು ಮುಗಿಸ್ಬೋಣ. Whatever it is.
Provide all that.
Papers ಕೊಡ್ತಾರೆ. The learned, the state is directed to be impleaded as a party respondent in the case at hand, representing the new CID, ಅಲ್ಲ CBI, representing the CID, the additional SPP.
Home Secretary or Chief Secretary of the part.
ಅವರಿದಾರಲ್ಲ ಪಾರ್ಟಿ ಹೆಂಗು. The petitioner, the learned senior counsel has emphasized on the fact that representations are given to the Home Secretary and the Honorable Chief Minister for seeking handing over of investigation to the CBI. In that light, the state is necessary to be a party to these proceedings. The petitioner is directed to implead the Secretary Home Affairs, Government of Karnataka as a party respondent to these proceedings. Learned additional SPP is directed to idara party? Idara party.
Yes.
Party idara ನೋಡಿ.
They're not part.
Ilva. So the learned additional SPP is directed to accept notice for the respondent. Accept notice for the respondent, petitioner to serve a set of papers upon the aforesaid council forthwith. List the matter on 22nd in the fresh matters list. Jagdish Awat will finish it. You ನೋಡ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ.
I will have provided him with everything by tomorrow, so.
Yes, sir. No problem. Yes. Sir. And if possible, get a modification to that order.
Yes, yes.
That appointing you. You try
I
to
will
get
take
a-
steps.
Yes.
I will make an earnest effort.
Yes, yes, yes. Reserve one ತೋರಿಸ್ಬಿಡಿ. But
27.
For the petition. At least not any to more than TDA mallet. What by decision, your lordship?
called by decision.
Please.
What called by decision?
Petitioners accused number 4 to 6, my lord. Brother, sister-in-law of the accused number 1, auntie of the first petitioner.
Respondent ಯಾರು ಇದಾರೆ? ಧನರಾಜ್.
ಜಾರಿಯಾಗಿದೆ ಬರ್ತಾ ಇಲ್ಲ ಅವರು
ಬರ್ತಾ ಇಲ್ವಾ?
ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿಲ್ಲ.
ಆ ತರ ಏನು ರೆಕಾರ್ಡ್ ಮಾಡಿಲ್ವಲ್ಲ ನಾನು. Heard the learned counsel Raju appearing for the respondent, petitioners. There is no representation on behalf of the complainant. A perusal at the order sheet would indicate that the complainant has been continuously absent. As a last chance, list the matter on Thursday in the fresh matters list. That is 21st in the fresh matters list. In the event the respondent would not be present, the matter would be heard and disposed on hearing the petitioner. Interim order subsisting will continue till the disposal of the petition.
Please.
28.
For the,
Entry ಮಾಡು maybe.
ಈಗಲೇ till the disposal of the petition.
for the petitioner in this case, my lord, sir, regarding 20% of deposit, my lord, sir, as per Jambu Bandar.
ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
No, as per Jambu Bandar's case, my lord, sir.
ಆಯ್ತು, ಯಾವಾಗ ಮಾಡ್ತೀರಾ? ಮಾಡಲ್ವಾ?
No, in this case, my lord, there is a delay of 18 days in filing the complaint, my lord. By suppressing that fact, they have filed a complaint. Admittedly, there is a
ಇದೆಯಲ್ಲ, ರೆಸ್ಪಾಂಡೆಂಟ್ ಬರಲಿ.
please.
List the matter on 11th December in the fresh matters list. Interim order subsisting will continue till the next date of hearing.
29.
Appear for the petition in this case.
I'm appearing for respond number 2, my lord.
Time ಬೇಕಾ madam?
I'm ready, my lord.
You're ready?
Yes.
My lord, in this case, my lord, is a commotion between the petitioners and the second respondent. They are the neighbors, my lord. There is a disagreement between the parking of the car in front gate of the petitioner house. No, my lord, there is a lot of
Car parking problem, huh?
Yes, my lord.
Yes, madam.
My lord, this is a case on counter case, my lord. There's another one more case registered by
Which is
me.
that number ಕೊಡಿ, ಎರಡು dismiss ಮಾಡ್ತೀನಿ. We'll dismiss both or allow both.
They have not filed the
My lord,
so for criminal
I
petition.
have not sought quashing for the petition case, my
Then
lord.
case and counter case ನಡೀಲಿ ಬಿಡಿ.
Please. In
ನೀವು
both the
ಹಾಕ್ಬಿಡಿ,
matters, my lord, charge
madam.
sheet is filed.
You also file a criminal petition, will quash both. ಏನ್ car parking problem?
Yes, my lord.
Yeah, criminal courts are crowded with such cases.
Yes. Stay may be granted, my
ಮನೆ
lord.
ಮುಂದೆ
till
ಕಾರ್
filing, my
ಪಾರ್ಕ್
lord.
ಮಾಡಿದ್ದಕ್ಕೆ ಜಗಳ,
Yes, my lord.
criminal.
My lord, offense, my lord, is under section 354, my lord, 427.
See, in all these car parking cases in the basement or outside, 354 will be there. ಇಲ್ಲ ರಿಜಿಸ್ಟ್ರೇ ಆಗಲ್ಲ.
364.
ಯಾಕಂದ್ರೆ ಮಿಕ್ಕಿದೆಲ್ಲ ಬರೀ 323 ಇರುತ್ತೆ.
Please. My lord, now my lord, matter is listed, my lord, for framing of charges, my lord.
Not yet charged, not yet framed, my lord.
You also file, madam.
Obliged.
Why do you want this rigmarole?
Stay may be
You
granted,
can
my lord.
settle.
Stay may be granted.
List the
my lord.
matter, list the matter on third list ಮಾಡ್ಲಾ?
Obliged.
List the matter on third. There shall be an interim order of stay of further proceedings square the petitioners till the next date of hearing. ಈಗ ಅವ್ರು ಬಂದೇ ಬರ್ತಾರೆ ಬಿಡಿ.
Much obliged.
Yes.
Obliged.
Appear for the petitioner, my lord. My lord, say in this matter, settlement talks are going on between the parties, my lord.
ಅದು ಆಯ್ತು, ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ್ಮೇಲೆ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್. ವೇರ್ ಇಸ್ ಮೇಡಮ್?
That she is appearing through VC, my lord. It appears that there are some network.
ಆಯ್ತು. Learned counsel for the petitioner submits talks of settlement are afoot AFOT. List the matter on
2 weeks time may be granted.
6th December. But 13th December. In the event the talks of settlement would not, the result of talks of settlement are not placed before the court, the matter would be considered on its merit. And the consideration on merit is only dismissal of the petition, as the charges have already been framed.
My lords, one more submission, my lord. Till such time, parties may be directed not to take precipitative action before the trial court.
ಎಲ್ಲ ಕೇಳ್ತಾ ಇದೆಯಲ್ಲ, ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ಫಸ್ಟ್. Yes.
Please, my lord.
31.
Waiting for the respondent.
Petitioner, my lord. Your lord, may kindly see that petitioners 1 and 2 are the father and son respectively. Second petition is working in UK.
madam. End of this month.
The alleged offence is under section 427, 448, 506 and 34. Your lord, may kindly see the second petitioner on the date of alleged incident date 8/2/24. He was not in India. Kindly take a look at page number 108, 10 and 11. The immigration entry, departure and arrival date is shown as 9/1/24, 6/7/9/1/24, and he arrived on 6/7/24. And boarding pass also have produced.
Even otherwise, A2 ಬಗ್ಗೆ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನೂ ಇಲ್ಲ. Not a single word.
My lord, my complaint, page number 26, my kindly.
I am at page number
26.
89. Summary of the charge sheet. A2 ಬಗ್ಗೆ ಒಂದು ಅಕ್ಷರ ಇಲ್ಲ.
This is related to crime number 186 of 2020.
ಇದು ಯಾವ್ದು ನಿಮ್ದು ಯಾವ್ದು ಸರ್?
Namdu crime number 16.
That is
ಅದು ಎಲ್ಲಿದೆ ಚಾರ್ಜ್ ಶೀಟ್ ಸರ್?
Charge sheet is not yet filled.
It is under investigation.
ಇದು ಯಾವ್ದು ಇನ್ನೊಂದು ಪೇಜ್ ನಂಬರ್ 70
It is filed by the accused.
That the petitioner have filed. They purchased this property from respondent 3 and 4.
Accused number 2 is not there in.
My lord, may kindly peruse the page number 26, sir. We have not stated that in presence of him only this incident taken place. The men of this accused number, none two.
If he is abroad, what is he?
My lord, may kindly peruse for a moment, page number 26, sir, where we have made the specific
ನೀವು
allegation.
ಮಾಡಿ ಬೇರೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ A2 ಮಾತ್ರ ಸ್ಟೇ ಮಾಡಿ.
One more, I would like to make a submission. Your lordship may kindly see that second complaint file is suit for bare injection saying that he is in possession.
We'll take it next week.
Adu vacate
Every
aagi.
week we'll stay one.
Please, please,
Every accused every week.
please.
One time ಇಲ್ಲ ಮುಗಿಸ್ಬೇಡ. ನಿಮ್ಗೆ ಯಾವಾಗ ಸಾಕಾಗುತ್ತೆ ಅಂತ ಹೇಳಿ ಅವಾಗ ಮುಗಿಸ್ಬೇಡ.
We are permitted to file the objection.
Yes. The learned heard the learned counsel appearing for the parties. The counsel for the petitioner taking this court through the documents appended to the petition would submit that accused number 2 was not in India on the period of alleged crime. Here, the learned counsel would take this court to the documents of immigration on stamp of immigration on the passport to demonstrate that he was not in the country. Therefore, there shall be an interim order of stay, qua the accused number 2 till the next date of hearing. Objections, if any.
My lord, it may be tagged with the criminal petition 8344 of 2020.
Tag this on. So next.
32.
To the respondent, my lord, I may be permitted to file objections.
Where is he? Doesn't come at all.
Yes, my lord.
Last time also irlilla.
Yes, my lord.
Not recorded it. The petitioner has been continuously absent. There is no representation. We have the petitioner even today. List this matter on Tuesday in the fresh matters list. In the event the petitioner would not be present, the petition would be dismissed for its non-prosecution.
Grateful.
Yes.
But I'm to argue this one, that's revision petitions.
Ivattೇನಾಗಲ್ಲ ಇದು.
Already
Take it
first
on
round, my lord.
28th.
First round, my lord, the 482 petition dismiss. Against discharge application.
ಇದ್ರಲ್ಲಿ ನಮ್ದು 482.
28th, list on 28th.
Very well.
Revision petition ಅಲ್ವಾ?
Please.
28, yes.
But interim orders.
Interim order ಇದೆಯಾ?
Well, it's deferring the charge.
Their problem. All right, yes. 28.
Please.
34.
Here for the respondent in this case.
ಏನಿದಲ್ಲ?
All these
20%,
petitions,
huh?
all these 8 petitions are challenging the concurrent judgments of the courts below for the offence punishable under section 138 of NA.
ಇಲ್ಲೇನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Revision ಹಾಕೊಂಡಿದ್ದಾರೆ. Challenging the
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್.
special court.
All right.
These are all revision petitions challenging the concurrent judgments of the courts below. All admitted transactions, all banking transactions.
ಇಲ್ಲೇನ್ ಸ್ಟೇ ಇದೆಯಾ?
Stay ಕೊಟ್ಟಿದ್ದಾರೆ last time.
Complied your honor. Right now, today it's not well.
ವೆಕೆಟ್ ಮಾಡ್ಬೇಡ. ಅದು ಅವರು ಅವತ್ತು ಹಿಂಗೆ ಇದ್ರು. ಸರ್ವೈಕಲ್ ಸ್ಪಾಂಡಿಲೈಟಿಸ್ ಎಲ್ರಿಗೂ ಇದೆ.
It was not, on that day is.
ಅದೇ ಹಲೋ ಅಂತ ಹೇಳಿದ್ರು, ನನಗೆ ಹೇಳಿದ್ರು, ಎಲ್ಲಿಗೆ ಹೇಳಿದ್ರು ಗೊತ್ತಾಗಿಲ್ಲ.
ಅದು VC disconnect ಆಯ್ತು. I have brought the certificate also. I am taking treatment from.
ಹಾಗಂತ ಎಲ್ಲಿವರೆಗೆ ಅಡ್ಜರ್ನ್ ಮಾಡ್ಬೋದು ಸರ್? ಅವ್ರು ಮಾಡ್ತಾರೆ ಬಿಡಿ.
ಅಲ್ಲ, ನಾನೇ ಹೇಳ್ಬೇಕು.
Serious matters, weeks time, 4 weeks.
4 weeks. I will give you 1 week's time. Next date ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು, ಇಲ್ಲಾಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ. Or vacate the interim order.
Petition ಇದೆ ಸ್ವಾಮಿ. Actually, I have deposited the amount.
I will hear the matter, sir.
ಅಲ್ಲ, ಯಾಕೆ ಅಂತಂದ್ರೆ ಅದು
ಈಗ ಡೆಪಾಸಿಟ್ ಅಮೌಂಟ್ ನ I will direct handing it over. I will ask him to withdraw. ಎಷ್ಟು ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರಾ?
50% amount deposit.
Sorry, he will withdraw it. The respondent will withdraw it. You take 4 weeks.
Subject to final ಇದೆ.
All right. ನೀವು 50% ತಗೊಳ್ಳಿ ಈಗ.
ತಗತೀವಿ ಸ್ವಾಮಿ, ಬಟ್ ಅಲ್ಲಿ ಏನಪ್ಪಾ ಅಂತ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲೇ ಇದು ಮಾಡ್ಬೇಕು ಅಂತ
ಫಿಕ್ಸ್ಡ್ ಡೆಪಾಸಿಟ್.
ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ನಾವು ಕೊಟ್ಟರೆ ದುಡ್ಡು ತಗೊಂಡು
ನೀವು ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ಕೊಡ್ಬೇಕು.
ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ಕೊಡೋದು ನಾವು ಮಾಡೋದು.
ಇಲ್ಲ, ಅದು ಹಿಯರ್ ಮಾಡೋದೇ ಬೆಟರ್. ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ದೆಲ್ಲ ಸ್ಪೆಷಲ್ ಪ್ರಾಬ್ಲಮ್ಸ್ ಇರುತ್ತೆ. ಹಿಯರ್ ಮಾಡೋದೇ ಬೆಟರ್. ಎಸ್, ಲೆಸ್ ದ ಮ್ಯಾಟರ್ ಆನ್ as a last chance, list this matter on 5th December. In the event the petitioner would not make his submissions, the interim order.
11th.
No. 5th December. In the event the petitioner would not make his submissions, the interim orders would stand automatically vacated. Yes, next. Settlement.
Quoting settlement 35. Yeah, here for the petitioner, my lord. The complainant has not present to the court. So
4 weeks bit on date for him.
no, 4 weeks, no. Next week, my lord.
List next 22nd, 2:30 PM, report settlement. Next.
Okay, I'm also close. 36.
Settlement.
Settlement. Petitioner.
ಏನು ground?
She's 17 years, 2 months and 12 days.
ಆಯ್ತು, ಅದಕ್ಕೆ
ಅವರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಸ್ ಅಗ್ರಿ ಟು
is in custody ಈಗ.
ಇಲ್ಲ.
ಬೇಲ್ ಇದಾರಲ್ಲ ಬಿಡಿ. ಸೆಟ್ಲ್ ಅಂತ ಮಾಡಲ್ಲ. No question of settlement. Will hear it on, will direct the concerned court to conclude the proceedings
Evidence
fast.
has been started.
Huh?
Their evidence has been recorded, will be directed.
Acquit ಆಗ್ತಾರೆ ಬಿಡಿ, because she will turn hostile. I will direct the court to conclude it within a time frame. Settle ಅಂತ ಮಾಡಲ್ಲ. Yes. List the matter on 20th in the fresh matters list. We'll close it. Next. Pokso ಯಾವ್ದು settlement ಮೂವೇ ಮಾಡಬೇಡಿ. ಅದು ಕೇಳ್ಬಿಟ್ಟು ಮಾಡ್ಬೇಕಿನ್ನು. 36. 36 ಇಲ್ಲಲ್ಲ. 36 ಇದೆ. 37. Offense.
Counter case was listed on 22nd.
Tag this petition along with so and so.
Criminal petition 1036.
Tuesday 2:30 PM. Yes. Wednesday, sorry. Wednesday 2:30 PM.
Again. 22nd.
22nd ಬೇಕಾ? 22nd, yes, 2:30. Next.
38.
498.
For the petitioner, your lordship.
Parties present.
Petitioner and respondent number 2 present.
All right.
I may be permitted to present join you.
ಕೊಡಿ. Anyway. 498.
Much obliged.
Order sheets.
ಹೋಗ್ಬಿಡ್ಬಿಡಿ. Much obliged. Yes. Next.
39.
Apparently have done next week, my lord.
22nd 2:30 to report settlement.
40.
Preparing for the petitioner in this matter, my lords.
Lords,
Compromise petition was already filed.
my lords, I appear for the de facto complainant. He's not been made a party to these proceedings.
ಇಲ್ದೆ settlement.
My lords,
Party ಮಾಡಿ first.
my lords, compromise petition was already filed and
Sir, make the complainant a party. What are you talking? Yes. Petitioner to implead the de facto complainant as a party respondent to these proceedings.
My lords, may I request a date to be fixed? Matters indeed been settled.
List on 22nd at 2:30 to report settlement.
Much.
Yes.
41.
My lords, inconvenience caused to the parties, my lords. Kindly get a date.
Notice has not yet gone to R2.
Huh?
Notice to R2. First time. 498.
Emergent notice to the second respondent returnable by 11th December. Yes, next.
Further hearing 42.
For a response. This matter had been heard for some time, but my lords, I'm now insisting on a stay for the
Why?
reason, my lords, I'll explain. For the reason, my lords, he's about 79 years old, US, my lords. A contract, my lords, of 2007. 2007, my lords, a tender is floated. I'm the successful L1, my lords. Under the tender, I was supposed to supply certain commodities, which I supplied.
Some difficulty today, my lords.
Alla, but my lords,
Please, my
what's
lord.
happening now is
Can you have
because
it on, my lords, Monday or Tuesday? My lords?
safety, my
Sir,
lords,
ಒಂದು ವರ್ಷದಿಂದ stay ಇಲ್ಲ ಇವಾಗ.
Alla, ಈಗ because now what's happened is because of his non-appearance, my lords, red corner notice in a matter, my lords, which is clearly covered by a contractual liability, and entire amount has been paid to me, my lords. I supply the product, entire amount is paid to me in 2011. Time bar debt, my lords. A complaint is given. That complaint now results with the present.
ಆಯ್ತು, ಯಾವ ಡೇಟ್ ಬೇಕು?
Tuesday, my lords.
Wednesday.
7 years delay ಇದೆ, my lords.
Wednesday. You come on merits will finish.
ಹೌದು,
Yes.
please.
List on Wednesday. Next. Heard so and so on party list on Wednesday.
Could it be in fresh matters, my lords? Now the problem is red corner notice and he's really struggling. 79-year-old man, my lords. On a contractual liability.
ಮತ್ತೆ ಒಂದು ವರ್ಷದಿಂದ ಯಾಕೆ stay ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಮತ್ತೆ?
Now the pressure is coming there, my lords. Because of the fact that he's not able to travel to India, my lords. He's in US.
Let's see. Yes.
Will it
List on, no. List on further hearing ತಾನೇ ಇರೋದು ಇದು.
ಹೌದು.
Release the matter from the status of being part heard, post the matter in the fresh matters list.
Fresh matters.
Yes.
Oblige.
43.
Defamation.
Respondent in this case, my lord. There's one more
But
tag
they have taken
matter.
a vow, my lord, not to argue. I pray, my lord, that 7, 8 adjournments are,
My lord,
my lord, on the same plea that they are asking adjournment, and this is harassment, my lord, more than the case. ಇದು ಪ್ರತಿ
no, my lords, there's a tagged matter. So we didn't
Don't
receive
worry
the
about the tag
copy.
matter.
it
You
may be
argue this
detagged,
matter.
my lord.
That has been detagged.
No, I am requesting it to be detagged because
Where is the
the
tag matter?
pleading has to be, my lord,
Where
complete.
is the tag matter?
ಅದೇ ಅದ್ರ ಜೊತೆ.
List ಆಗಿದೆಯಾ ಇಲ್ಲಿ?
Rising out of the same PCR.
Oh, ಇದಾ? Yes. ಅದ್ಯಾಕ್? Why is this tag?
Last time.
ಅಲ್ಲ ನಾನೇ ಹೇಳಿದ್ದೆ that not ಅದ್ರ ಜೊತೆ ತಗೊಳ್ಳಿ, not to tag. I had only not.
D-link 43.1. Yes, now start 43.
My lords, a short accommodation may be given. my
Kindly see,
lords.
my lord, how many adjournments are taken?
The respondent, right from the beginning, has been taking the time and not even on not even a single occasion has made her submissions. As a last chance, list this matter on Thursday, on Wednesday in the fresh matters list. In the event the respondent would not submit, the matter would, the petitioner, counsel of the petition would be heard and orders would be passed. Yes, list the matter on.
Interim order.
Matter, respondent is served. But I.
Interim order subsist, wait. Interim order subsisting will continue to the, Dalwai Venkateshal, you are taking notice in this?
Connected matter.
Yes, my lord.
Avarge same, are you taking?
Yes, if they.
It is the same complainant. Soumya Reddy is the complainant in this also.
We have no instruction from
Then
the
leave
client.
it. Yes. The dealing matter list after 2 weeks. Interim order subsisting will continue to the next date of hearing in both these cases. Yes.
Great. Monday.
22 years, yes. Yes, madam, complainant. Hello, madada.
ಸ್ವಾಮಿ ಅದೇ ನಮಗೆ 8 ಲಕ್ಷ ಎಲ್ಲ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತ ಹೇಳ್ತಾರೆ, ಮತ್ತೆ ಅವರು 20 ವರ್ಷ ಅವ್ರ ಜೊತೆ ಟೈಮ್ ಸ್ಪೆಂಡ್ ಮಾಡಿದ್ದಾರೆ, ಅದಕ್ಕೆ
ಅದಕ್ಕೆ offense of rape ಆಗತ್ತಾ madam? After 22 years of living as a couple, you allege rape. Is there any semblance of fairness in the allegation? 22 years, not 1 varsha, 2 varsha. After living for 22 years, offense of 376, 417, 420 on promise of marriage.
Yes, my lord.
Anything else? Yes, sir. When do you start arguing the matter? ಏನ್ ಹೇಳಿದೆ? This is the time you should start when senior is not. Senior ಬಂದು ನೋಡಿ. Yes, madam.
Nothing, my lordship.
Nothing. ಎಷ್ಟು ಲಕ್ಷ ಇಸ್ಕೊಂಡಿದ್ದೀರಾ?
8 lakhs, my lordship.
8 ಲಕ್ಷ ಇಸ್ಕೊಂಡಿದ್ದೀರಾ? ಎಷ್ಟು ಶಾಂತಿಭೂಷಣ್? 8 ಲಕ್ಷ ಇಸ್ಕೊಂಡಿದ್ದೀರಾ?
That's only the allegations, my lord.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರಾ?
Yes, my lordship.
That's only,
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ?
charge sheet is fine. Look, the two decisions of the apex court. the lat-
ಡಿಸಿಷನ್ ಬಿಡಿ ಸರ್, ನಾನೇ ಕೊಡ್ತೀನಿ.
The latest one.
ಲಾಲು ಯಾದವ್ ಸರ್.
And the other one, my lord, Sheikh Arif was.
ಶೇಖ್ ಆರಿಫ್ ಅಲ್ಲಿ ಒಂದೇ ಒಂದು ಸ್ಟ್ರೇ ಸೆಂಟೆನ್ಸ್ ಇದೆ ಸರ್, ಅದು ಬೇರೆ ಏನಿಲ್ಲ, ಅದು ಕನ್ವಿಕ್ಷನ್ ಆದ್ಮೇಲೆ ಹೋಗಿರೋದು. ಜಸ್ಟಿಸ್ ಓಕ್ ಅವ್ರದ್ದು.
Please,
ಎಸ್.
please. For nothing.
ಇನ್ನೊಂದು ಶಿವ್ ಸಿಂಗ್ ಇದೆ, 2024 8 SCC on the same issue.
And one more, my lord, Marshal Vaidya, my lord. was the
ಅದು
state-
ಅಷ್ಟೇ, ಅದು ಅಗೇನ್ಸ್ಟ್ ಕನ್ವಿಕ್ಷನ್ ಆದ್ಮೇಲೆ 482 ಅಲ್ಲ.
That's in appeal.
ಅದೇ ಅಪೀಲ್, ಎರಡು ಅಪೀಲ್ ಅಲ್ಲೇ ಶೇಖ್ ಆರಿಫ್ ಅಂಡ್ ಅವ್ರದ್ದೇನಿಲ್ಲ ಅಂತ. ನಥಿಂಗ್ ಮೇಡಮ್.
ಅದೇ ಸ್ವಲ್ಪ ಅಮೌಂಟ್ ಏನಾದ್ರು ಕೊಡ್ಸ್ಕೊಟ್ರೆ.
ಅಮೌಂಟ್ ಕೊಡ್ಸ್ಕೊಡಿ. ನೀವು ರೇಪ್ ಕೇಸ್ ಹಾಕದೇ ಇದ್ದಿದ್ರೆ ಏನಾರು ಮಾಡ್ಬೋದು. ಅರೆಸ್ಟ್ ಆಗಿದ್ರಾ?
Anticipatory bail.
ಬೈಲ್ ತಗೊಂಡು. ವೆರಿ ಅಂತ 22 years ಆದ್ಮೇಲೆ ಜೊತೆಗಿದ್ದು ರೇಪ್ ಕೇಸ್ ಹಾಕ. You're living in for 22 years.
But yes, my lordship.
Yes. Yes. Allowed cost.
Great. I'm sorry, my lord, I was on my legs.
No problem.
$45.
Guidelines for premature release.
ಏನಿದು?
Guidelines for premature release, your lordship.
Yes, sir.
I've just received copy today, my lord. Your lordship may have it on Friday.
And its copy was given, only IA copy, once again we.
ನೋಡಿ, see, this has, there's wide ramification
Please.
throughout the nation.
Please.
He is asking laying down of guidelines for premature release. Every state has done it.
Please.
Because Ministry of Home Affairs has to ratify it. You are here. ಅದಕ್ಕೆ ಒಂದು ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ. ಅಷ್ಟರಲ್ಲಿ ಹೇಳಿ, ವಿಲ್ ಡಿಸ್ಪೋಸ್ ದಿ ಮ್ಯಾಟರ್ ಬೈ ಫಾಲೋಯಿಂಗ್ ಸೆವೆರಲ್ ಅದರ್ ಸ್ಟೇಟ್ಸ್.
Please, my lord, please.
Take it on Friday.
One finding should be given that one accused has been released, recommended for premature release, then other accused are not recommended because of their different, in different prisons and.
That we'll see. That we cannot paint everybody with the same brush. We'll see. Yes.
Same cases.
22nd. 22nd fresh matter le ಹಾಕ್ತೀನಿ.
May I request, my lord, for the week starting from 25th, my lord.
All right. Then I'll take it on 26th.
Please.
26th, release the matter from the status of being part heard, list the matter on 26th in the fresh matters list.
Great.
GM ಇದು ಬೇಡ, ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಇರಲಿ. ಅಲ್ಲಿ GM ಇದು. Yes.
Please.
At 2:30 or 3:30 minutes, we'll reach minutes.
We'll
Otherwise
take it at 4 o'clock. On
Please,
26th.
as my learned friend says.
ಅವರು ಎಂಡಲ್ಲೇ ಬರೋದು ಯಾವಾಗ?
Because he has got many payroll matters that is.
ಏನು?
$46.
Seek permission to appear for petitioner counsel, my lord.
ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ನಾಗ. ಎಸ್. ಇವ್ರನ್ನ ಏನ್ ಮಾಡ್ತೀರಾ ಸರ್? ಟೊಬ್ಯಾಕೊ ಚ್ಯೂಯಿಂಗ್ ವಿ ಹ್ಯಾವ್ ಸ್ಟೇಡ್. ಸ್ಟಾರ್ಬಕ್ಸ್ ಕಾಫಿಗೆ ಯಾಕೆ ಪ್ರಾಬ್ಲಮ್?
ಅಲ್ಲ ಇದಲ್ಲ, ಇದು NDPS case.
ಇದು NDPS.
ಹೌದು,
ಅದು
NDPS.
ಬೇರೆನಾ?
ಅದು ಬೇರೆ. This is NDPS, my lord. Protection is Paritosh. Paritosh, my lords, the 67th statement, that is Tufan Singh, my lord. He cannot
ಆರ್ಗ್ಯೂ
be.
ಮಾಡಿದ್ರ ಮುಂಚೆ?
It has been heard, my lord. I have argued on 52A, my lord.
ಓ,
Then-
ಇದೇ ಕೇಸ್ ಅದು. ನಾ ಡಿಡ್ ನಾಟ್ ಸಿ ದಿ ಕಾಸ್ಟ್ ಶೀಟ್. ಇವಾಗ ನೋಡ್ತಾ ಇದ್ದೆ. ಬಟ್ 52 ಫಾಲೋ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಇದು.
ಹೌದು, that's been done, my lord.
ಮತ್ತೆ
Is now contention is only based on a co-accused statement. My second,
ಏನ್ ತೊಂದ್ರೆ ಆಗ್ತದೆ ಇದರಿಂದ?
my lord,
ಅಲ್ಲೇ ಇದ್ದೀರಾ?
I have to face this particular proceedings, my lord.
And the statement of a co-accused.
ಅಲ್ಲ, is inside the prison, huh?
He was inside that relevant when the seizure took place, my lord. I was inside the prison, my lord.
Where did the seizure take place?
Outside, my lord. Outside in the.
MDMA ecstasy ಹೆಂಗ್ ಬಂತಲ್ಲಿ?
Alala, Caesar not from his possession, Caesar from others.
Then how are you attributing our voluntary statement here?
Yes, my lord.
I'll place my.
What will place? He was inside the prison and outside somebody says it is Wilson Garden, Naga, and you have said.
That is the problem. Name is the problem.
Voluntary statement. Voluntary statement.
Sorry, ma'am.
Voluntary statement.
The voluntary statement of that particular accused number 1 and my.
You are drawn as accused number
2, my lord. Page number 65 is the statement of the accused number 1, my lord. He says that he had given the information.
Objection haki. Heard the learned counsel Madhukar Deshpande appearing for the petitioner. The petitioner is a convict under trial.
No, he is detained under preventive detention law.
The petitioner is detained under preventive detention and is said to be involved in the present proceeding. A seizure takes place in which certain MDMA and LSD is seized from accused number 2. Psychotropic substances are seized from accused number 2. The accused number 2 on interrogation reveals the name of accused number 1. Therefore, the axe has fallen on accused number 1.
Sorry, my lord. It is the other way, my lord. Accused number 1 makes a statement and
That
implicates accused number 2.
So and so. The petitioner, you are accused number 1.
No, I am accused number 2, my lord.
The petitioner accused number 2 on the said date of seizure was in prison and the seizure happens somewhere outside the prison. And on the voluntary statement of accused number 1, the petitioner is named as accused number 2. In these circumstances, the petitioner would get the benefit of what the apex court has held in Tufan Singh versus so and so, 2021 4 SCC, 1 SCC page 4, page 4, paragraph 151.1 and 151.2. 155.1 and 155.2. The court ಮಾಡಬಿಡಿ. Therefore, there shall be an interim order of stay quay the petitioner till the next date of hearing.
Disposal. That is the reason why, my lord, it has been heard from time to time.
Interim order ಕೇಳಿಲ್ಲ. I will dispose it if that is the case.
I am relying upon Paritosh, my lord. Paritosh is the judgment, my lords have. I have filed it on the last date of hearing.
Yes, disposed.
But the Paritosh covers the entire things.
Copy paste ಮಾಡಬಿಡಿ. ಅದ್ರಲ್ಲಿ 3 judgment ರಿಲೇ ಆಗಿದೆ.
Yes, my lord.
Yes, my lord. Next.
Banking upon Tufan Singh, my lords have.
That's 155.1 and 2, right?
Yes, my lord.
Yes. Next.
37.
ಬಂತ ಮೇಡಮ್? ಎಲ್ಲ.
First there was a seizure, then my lord search started.
I need to file my objection. ಇದೇನು ಸರ್? ಸೀಜರಾ?
First they passed an order of seizure.
Drugs ಆ?
PMLA proceedings.
PMLA.
Then they started search.
ನೀವು ಆ ಸೀಜರ್ ಇಂದ ಈ ಸೀಜರ್ ಹೋಗ್ಬಿಟ್ರೆ ಗೊತ್ತಾಗ್ತದೆ. Yes.
I need to file my objections.
File your objection. Heard the learned senior counsel.
There is already my lord.
I know. Heard the learned senior counsel V. Lakshmi. ಅದನ್ನು ಹೇಳ್ಬಾರ್ದಾ?
Sorry.
Heard the learned senior counsel V. Lakshminarayan appearing for the petitioner. The learned counsel representing P. Prasanna Kumar seeks 2 weeks' time to file statement of objections. Objections, if any, in the next 2 weeks. Interim order subsisting will continue till the next date of hearing. List the matter on 12th December. Please.
But your lordship passed an interim protection appearance on 23/10, but there are 2 conditions. I have to appear and then file return submission.
ಇಲ್ಲ, I have exempted you from appearance.
But return submission ಅಂತಿದೆ. Tomorrow they should not raise.
ಏನ್ ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಗೊತ್ತಾಗಿಲ್ಲ. Interim order ಇಲ್ಲ ಮೇಡಮ್.
Further proceedings as per.
ಮಾಡಿದ್ದೀನಲ್ಲ.
ಇಲ್ಲ, further proceedings. Page 183.
This is with regard to my lords, the
In
adjudicating
fact, they
authority.
passed an order.
Summons shall be deferred ಅಂತ ಮಾಡಿದ್ದೀನಿ.
Summons shall be deferred.
Ah.
This is my lords, the show cause notice, my lords, issued by the adjudicating
Only
authority.
summons, shall
Not
be
before me,
deferred.
my lords. This is adjudicating authority.
Nandralli seizure.
All right, you file your objections.
Please.
ಇದೇನಾಗಿದೆ predicate offense ಏನಾಗಿದೆ?
Predicate offense, there is a stay, my lords.
All right, till such time, the respondent enforcement directorate shall not precipitate the matter. Yes. Next. ಈಗೇನ್ ಕರೆಯಲ್ಲ ಬಿಡಿ. They will not call you now.
Like literally.
Yes, next please. Getting madam.
49, hearing on I-49.
ಅಯ್ಯೋ ಇದು ಈಗ ಆಗಲ್ಲ 5 ಗಂಟೆ ಆಯ್ತು. Now we can't do this. Next. Call 450th.
49, my lords.
5:15 and 49. Sir, 49 can't be now. It takes long time. 14% ತಾನೆ?
Please, my lord.
14%, now he has engaged the council.
All right. Engage the council.
Yes.
Please, my lord.
ನಿಮಗೆ ಟೈಮ್ ಬೇಡವಾ? ರೆಡಿ ಇದ್ದೀರಾ?
Any date. Very short point, Lord.
Any date.
Time is also very short, not now.
Any date may be fixed, my lords.
Next Friday, 22nd. Yes.
My lords, maybe on 26th or 27th.
27th. Yes.
Much of.
List on 27th.
Interim order.
My lords,
Joint
other
Senior Council interim
three
order
matters are
continues.
there, my
Next,
lords.
yes.
Other 3 matters should be connected.
ಕೊಡಿ numbers.
Lord,
ಬೇಡವಾ?
Lord, ಅಲ್ಲ ಅದು ಇದ್ರೊಳಗೆ ಏನಾಗುತ್ತೆ ಅದ್ರೊಳಗೆ ಆಗುತ್ತೆ. ಅದೇನು ಇದ್ರ ಜೊತೆಗೆ
ಒಟ್ಟಿಗೆ ಆಗ್ಲಿ ಬಿಡಿ. ಬೇಡವಾ?
The issue is whether BDA had any right.
ಆಯ್ತು.
That's the issue.
No
That can be decided here and applied elsewhere.
No problems. Yes.
Anything.
Much obliged. my lord.
50.
Number 50.
ಅದೇ ಲಾಸ್ಟ್ ಮೇಡಮ್. ಬಸವರಾಜ್ ಸರ್ ಇದ್ದಾರೆ.
Flesh and blood case. You covered by your lordship.
ASG is arguing the
ಓ ಇದು PMLA da?
Yes, yes.
Oh, all right.
All the scheduled
challenging the
offences are
adjudicating authority proceedings.
Predicate offense?
they are stayed.
My lord, no, our submission is that, my lord, the proceedings what we
What
have
accused
initiated
are
is a
you?
civil action.
I'm not even accused.
Then?
It is a civil action
2008,
what
what
we have
he-
initiated.
After
What's the
15
matter?
After 15 years, somebody files a complaint taken at somebody,
Huh.
by name some Goli Naga or something like that, saying that
Huh.
he threatened him with a knife to sell the properties. About 15 years.
Sell the properties to you.
No, somebody else.
Eh?
Then,
Huh.
based on that, FIR was registered in 2020 to 23. I
Huh.
purchased the property much earlier.
Hmm.
Now, 2 more FIRs were registered saying, well, it's like a soap opera. Now, all these proceedings are stayed. On the ground, it's a complete abuse of process of law.
Hmm.
Now, 17 proceedings are initiated. My properties are attached and application is filed under section 17 for the purpose of retention.
Hmm.
To initiate the proceeding section 8(3) for confirmation. Absolute, the only allegation against me, my lord, page 32, the only allegation is that I am likely to purchase another property worth 100 crore. This is the only allegation against me.
My lord, the proceedings under section 17, my lord.
He is
And
not
he
an
suppose
accused.
it
One
is a
minute,
time-
sir. 1 minute, sir. He is not an accused.
He is not an accused.
You are purchaser of property?
Yes, yes, yes.
Purchaser of a property. From whose hand? From the hands of the accused in the predicate offense?
Yes, yes.
In the predicate offense,
Yes,
correct? Is that so?
Prior to the registration of the FIR, prior to the so-called offense.
Prior to the registration of the predicate offense, sir.
Yes, yes, yes.
Lord, learned
What
ASG
is this?
Learned ASG will argue the matter, my lord. He was here. Kindly have it tomorrow, my lord. He will address the argument.
It's an
he's-
open and shut case.
It was heard, my lord, then it was, my lords posted the matter.
All
for
right, Wednesday 4 PM ಏನಿದೆ madam? Yes. Heard the learned senior counsel as Basavaraj appearing for the petitioner. List the matter on Wednesday at 4 PM.
Yes.
With further hearing ಇದೆ anyway.
Yes.
Yes, for further hearing. 33 matters for it.
Lords, one submission, my lords. Serial number 4 in the list, my lords. Memo for hand delivery of the order.
ಇವಾಗ ಅವಾಗ್ಲೇ ಆಗಿದೆ ಅಲ್ವಾ?
ಆಗಿದೆ sir.
ಕೊಡ್ತಾರೆ. ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ ತಗೊಂಡು.
ಅಲ್ಲ, I'll receive it
I
in
have
the
to go and
morning.
sign, sir. ಆಮೇಲೆ hand delivery ಆಗುತ್ತೆ.
We permitted
We
by
get it.
submission, Lordship. There is an emergency, urgency is that
Yes, sir.
the bail petition had been stayed by this honorable court yesterday.
Bail petition has
Yes,
been
further
stayed.
proceedings had been stayed. It is listed for tomorrow. May kindly be taken at the
No,
top of the list.
How have state bail petition?
The reason is the
victim wants to implead in the
302
application.
application.
350 ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ, ನಮ್ಗೆ ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮಾಡಕ್ ಕೊಡ್ಬೇಕು, ನಮ್ಗೆ ಅಸಿಸ್ಟ್ ಮಾಡೋದಿಲ್ಲ ಅಂತಾರ ಅವ್ರು.
That your lordship.
Oh, yesterday.
Yes,
further
yesterday's
proceedings they
matter.
made.
And trial court is posted for tomorrow. If matter is disposed in the early in the morning, so they can able to argue in the evening.
Tomorrow ಗೆ ಕಷ್ಟ ಆಗದೇ ಇಲ್ಲ.
Tomorrow, the matter is listed tomorrow.
No, ಅಲ್ಲಿ ಆಗಿದೆ.
ಇಲ್ಲೂ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಇಲ್ಲಿ ಆಗಿದೆಯಾ?
ನಾವು ಕೇಳ್ತಾ
ಬರುತ್ತೆ ಬಿಡಿ.
ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಕೇಳ್ತಾ, ಯಾಕಂದ್ರೆ ನಾಳೆ ಎಂಡ್ ಆಫ್ ದ
ಬೆಳಿಗ್ಗೆ 10:00 ಮೆನ್ಷನ್ ಮಾಡಿ ತೊಂದ್ರೆ ಇಲ್ಲ. 10:00 ಮೆನ್ಷನ್ ಮಾಡಿ.
Other side advocate will not appear. So that's the reason. Top of the list is he'll appear.
ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. ಯು ಮೇಕ್ ಅ ಮೆನ್ಷನ್, ಅದರ್ ಸೈಡ್ ಅಡ್ವೊಕೇಟ್ ಹೇಳಿರಿ ಈಗಲೇ. ಆಲ್ರೈಟ್.
ಎಸ್.
ಐಸ್ ಬೇಡ. ನಾಳೆ ಲಿಸ್ಟ್ ಆಗಿದೆ ಅಲ್ವಾ?
ಲಿಸ್ಟ್ ಆಗಿದೆ, ನಾಳೆ ಡೇಟ್ ಇದೆ ಸ್ವಾಮಿ.
ಆಯ್ತು, ಡೋಂಟ್ ವರಿ. ಎಸ್.
Removed matters. Dilemma 1, Rajeshwara PN.
We are the brokers, my lords.
Brokers.
Andre real estate brokers. Cheating case is filed against us because there was some earlier sale deed in favor of the other person. 2 civil suits are filed by the purchasers, one by the de facto complainant, another by the person who.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಸ್ ಜಗದೀಶ್.
Take not precipitating. Seems
Learn
to
it,
be large amount is it? Seems to be large amount.
ಎಷ್ಟು ಅಮೌಂಟ್?
ನಮ್ಗೆ 25 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತ ಅವ್ರ ಅಲಿಗೇಷನ್. 2 ಕೋಟಿ.
ಅಕ್ಯೂಸ್ ನಂಬರ್?
ಅಕ್ಯೂಸ್ ನಂಬರ್ my lords 4 and 5.
ಹೆಂಗ್ ಬಂದಿದೆ ನಿಮಗೆ 25 ಲಕ್ಷ?
ಅಕೌಂಟ್ ಅಲ್ಲೇ ಬಂದಿದೆ.
ವಾಪಸ್ ಕೊಡಿ.
ನಾವು
ವಾಪಸ್ ಕೊಡಿ.
ಅದ ಚಲಿ my lords
ಬ್ರೋಕರೇಜ್ ಅದು?
ಬ್ರೋಕರೇಜ್ ಅಲ್ಲ.
ಮತ್ತೆ
ಅದು ಅವ್ರು ಕೊಟ್ಟಿರೋದು, ಓನರ್ ಕೊಟ್ಟಿರೋದು, ನಮ್ಮ ಹತ್ರ ಕೊಟ್ಟು ಅವ್ರು ಕೊಡ್ಸಿರೋದು.
ಯಾಕೆ ಇವೆಲ್ಲ ಮಾಡ್ತೀರಾ?
ಏನೋ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗ್ಲಿ.
ಎನಿವೆ 25 ಲಕ್ಷ ಕೊಡ್ಬೇಕು ವಾಪಸ್ ಈಗ.
ಅಲ್ಲ, ಕೊಟ್ಬಿಟ್ಟಿದೆ ನಾವು ಇವ್ರಿಗೆ.
ಓನರ್ ಯಾರು? ಅಕ್ಯೂಸ್ ನಂಬರ್?
ಅಕ್ಯೂಸ್ ನಂಬರ್ 7 my lords.
ಓನರ್ ಆಲ್ಸೋ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಗಿವ್.
And Narsimpura 1 and 2 my lords.
ಯಾರೋ ಮನೆ ತಗೋಬೇಕು ಅಂತ ಬಂದ್ರೆ ಅವ್ರನ್ನು ಹುಡ್ವಿಂಗ್ ಮಾಡಿದ್ರೆ ಇನ್ನೇನಾಗುತ್ತೆ?
ಇಲ್ಲ, 1 ವರ್ಷ ಆದ್ಮೇಲೆ ಸೇಲ್ ಡೀಡ್ ಆಗಿ 1 ವರ್ಷ ಆದ್ಮೇಲೆ
ಯಾಕೆ ವಾಪಸ್? ನಾಟ್ ಹ್ಯಾಪಿ ವಿತ್ ದ ಪ್ರಾಪರ್ಟಿ?
that I don't know. Enter into a joint development agreement. Joint development agreement ಆಗಿದೆ.
ಎಲ್ಲ ಆದ್ಮೇಲೆ ನಿಮ್ಮ ಮೇಲೆ?
ಎಲ್ಲ ಆದ್ಮೇಲೆ ನಮ್ಮ ಮೇಲೆ ಕೇಸ್ 1 ವರ್ಷ ಆದ್ಮೇಲೆ.
The learned counsel for the petitioner submits that petitioners had brokered a sale of a property with the complainant and accused number 7.
1 and 2. 1 and 2.
Accused number 1 and 2.
7 previous owner, present owner 1.
Right, accused number 1 and 2. The brokerage has resulted in an offence under section 406, 420 and 120B. In the light of in the light of no role apart from the brokerage by these petitioners, I deem it appropriate to grant stay of further proceedings, further investigation in crime number so and so till the next date of hearing.
Yes.
1 additional SPP, 2 emergent notice. Next.
Yes.
Number 2, Raju S.
Please, page 18, return complaint, 7 page return complaint.
ಏನ್ ರಾಜು ಅವರೇ?
1 ಲಕ್ಷ ಚೆಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಪೊಲೀಸ್ ಹರಾಸ್ಮೆಂಟ್.
ಪೊಲೀಸ್
1 ಲಕ್ಷಕ್ಕೆ
2 ಕೋಟಿ ಆಗುತ್ತೆ 1 ಎಕರೆ.
1.5 crore. 1.5 crore is agreed.
ಇವ್ರು ಕೊಟ್ರದ? ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ?
ನಾನು ಕೊಟ್ಟಿಲ್ಲ. 1.4
agreement ಮಾಡ್ತಾರೆ.
1 additional SPP, 2 emergent notice returnable by 3rd December. There shall be an interim order of stay of further investigation. Pay these petitioner still the said date. Yes, next.
Number 3,
I appear for petitioner's counsel, my lord. This is a matter where, my lord, a tweet alleged to have been made by the petitioner.
Yes.
Yes, my lord.
Why, sir?
353.
353?
153.
Yes,
153.
Kindly see the utterances.
BNS, my lord. Page 26 complaint, my lord.
A farmer.
Page
26. A farmer in the
highlighted portion. Your
Oh,
Lordship.
if the farmer in Haveri
He
commits
commits
suicide.
suicide after finding his land is taken over by WAF.
Hmm.
In their haste to appease minorities, CM Siddaramaiah, Minister so and so have unleashed catastrophic effects in Karnataka that are becoming impossible to contain with every passing day.
Hmm.
My Lord.
Hmm.
These utterances, my Lord,
Hmm.
would it not
Hmm.
hurt the sentiments or feelings?
Correct.
Yes. Yes. In what manner?
What is being done? is
Promote
not-
enmity.
No, no. What
Yes.
is being done is correct.
What is being done, my Lord?
Yes.
Is this a fact? Is this a fact?
It is a fact is what he says.
He might say,
Yes.
he should substantiate that.
We'll
He
do
cannot
it.
blindly say this.
Substantiate ಮಾಡಿ 153 ಗೆ ಬರಲ್ಲ sir.
ಬರುತ್ತೆ.
ಬರಲಿ.
ಅಲ್ಲ. Is it not promoting enmity? There are ways and means to protest in a democracy. You have dissent, you have protest. There are certain rules, there are certain modes. You cannot say something. And that's what Supreme Court also says.
Yes, sir.
Yes.
Correct.
So therefore, we will place all that on record. But this prima facie would promote enmity between the two groups, two castes, my Lord, religion. Castes, my Lord, is it a fact that somebody committed suicide?
Yesterday I was telling every action has an equal and opposite reaction.
Yes.
That is the result.
My Lord, where is the action now? We cannot assume some action is there. We cannot assume.
Action is there, that has resulted, my lord.
Ida.
They started issuing, my lord.
Off. My Lord.
Where is the action?
Off ಆಯ್ತು.
The government has done something. There are ways in which to protest. You cannot say because CM Siddaramaiah, this party has appeased some community, somebody has committed suicide. These are bullshit. Doesn't fall within the.
Doesn't fall within 153.
No, not for damages. It falls really. Provisions of 153. Otherwise, 153 would be redundant. These are not the cases which are being taken cognizance of. Where is the answer? Place was between the judgments were rendered by the.
Judgments I will give, sir.
No, he also asked.
I will give, sir. Shiv Prasad Semwal, Javed Hajam.
Javed, yes.
Yes, sir. What Supreme Court has said, what would amount to 153?
Yes. Not Supreme Court would say there are ways and means to protest.
Yes.
In a democratic setup. There are reasonable restrictions, my Lord. Every chapter 2, my Lord, fundamental rights.
The restriction should be only for the other side, is it?
My Lord,
Restriction.
Lord, court will now take each case. ಹೌದು ಅದರಲ್ಲಿ ಇಲ್ಲಿ ಬೇರೆ ನಮ್ಮ ಮುಂದೆ ಇಲ್ಲ. These utterances, my Lord, if allowed, merely to say even the other community does that and so.
No, I'm not saying so. Did I say so?
No.
Nothing. You are saying so. I am not saying anything.
No, Your Lordship said something else. I did not get it, my Lord.
All right. Yes.
No, to say, is it a fact that somebody committed suicide because he did this? So that does it not promote?
All right.
Lord,
Yes.
government policies may be bad.
My lord, what has happened is, my lord, this was a news based on news report. He has tweeted it. My lord, the news report was on the basis of the interview given by the father of the deceased, and also, my lord, a article written. My lord, that is on record. That is everywhere. It is there. And based on that, tweet has been done. Now the tweet has been deleted also subsequently after the police issued clarification. Now, my lord, at any event,
Police
my lord,
issued police, what clarification police issued?
police said, my lord, the death was due to, my lord, loan amount, heavy loan amount and all.
All right.
But the fact remains, my lord, the name of Waqf has been entered in his RTC. That fact is there. Therefore, that is a matter of investigation and trial, my lord. Now, at this stage, my lord, RTC also we have annexed along with the petition. But there is something, my lord, not that nothing is there.
22 ಸತ್ತಿದ್ದು.
ಅಲ್ಲ, ಸಾಯಿಲ್ ಯಾವಾಗ ಎಂಟರ್ ಆಗಿತ್ತು, RTC ಹೆಸರು ಎಂಟರ್ ಆಗಿತ್ತು. That is the grievance.
ಸತ್ತಿದ್ 22 ಅಲ್ಲ?
Yes, my lord. But the RTC, the entries were there in the RTC. But now ultimately tweet has been deleted. My lord, it is based on.
ಹೆಸರಲ್ಲೂ ಇವ್ರದ್ದು ಹೆಸರು ತೋರಿಸ್ತಾ ಇದೆ ಕಲ್ಟಿವೇಟರ್ಸ್ ಕಾಲಮ್ ಅಲ್ಲಿ. So
Annexure
therefore, I will have my say. Kindly grant, sir, there is no urgency. ಇದ್ರಲ್ಲಿ ಏನು ಅಂತದ್ದು ಹೆಚ್ಚು ಕಮ್ಮಿ ಆಗೋಂಥದ್ದು ಏನಲ್ಲ. We will, my lord, your lordship will have to interpret your judgment ಮಾಡಿ ನೀವು ತಮ್ಮ ಕೈಯಲ್ಲಿ ಒಂದು ಜಜ್ಮೆಂಟ್ ಆದ್ರೆ ಅದು ಉಳಿತದೆ. ಸೊ ಅದರಿಂದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಬೇಡ, ನಿಮ್ ಕೈಯಲ್ಲೇ ಒಂದು ಜಜ್ಮೆಂಟ್
ಬೇಡ ಬೇಡ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಬರ್ದಾಗ
ಅಲ್ಲ ಅದನ್ನ ಮಾಡಿ
ಫಾಲೋ ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ ನಾವು.
Follow ಮಾಡಿದ್ರೆ
there not be a stay. I will no may not.
But absolutely there is no ingredients.
22
madam.
ಸತ್ತಿದ್ದಾರೆ.
Assuming, my
22
lord,
ಸತ್ತಿದ್ದಾರೆ.
everything is correct, also there is no ingredient.
What the learned senior counsel says is what was told to him.
Can't say, you can't utter saying something. Tomorrow he will have an attack, something more without.
I'll record this statement.
Yes, yes.
When other cases come.
Alala, correct.
You can't utter something, whatever comes to your mind.
Yes.
Is what you are saying.
Yes. Certainly, my lord. No one can. What I am saying is Article 19 has some restrictions, reasonable restrictions.
That's to every citizen, sir.
My lords?
To every citizen.
Yes. So, ಗೌರ್ಮೆಂಟ್ ಅಪೀಸ್ ಮಾಡಿದ್ದಾರೆ ಒಂದು ಕಮ್ಯುನಿಟಿಗೆ, ಈ ಇನ್ನೊಂದು ಕಮ್ಯುನಿಟಿ ಸತ್ತಿದ್ದಾರೆ ಅಂದ್ರೆ it will definitely fall within 153A is what I'm saying. So therefore, it could be.
It is at best criticism of the policy of the government.
Yes,
Dissent.
That will not come within 153A.
No. This statement is not a protest.
19.
It is not a dissent. If he had said that this policy is bad, the government could not have, in my view, the government could not have done this. It is bad. Here, saying that a particular community man committed suicide.
Party cannot say how it has to be opposed.
Huh?
How it has to be criticized.
You express your opinion. You can't say something more than this
part.
is not the opinion. This cannot be opinion. This is promoting enmity is what I'm saying. This is promoting enmity, my lord. This is not an ordinary language where he says, no, this policy of the government is bad. So therefore, this is my dissent. No. He has done something. He has appeased those minorities. So this is, your policy is bad in the categorically, let him say. Then there is some meaning to it.
Yes, sir.
My lord, let it be heard.
That's what I'm doing.
Let it be heard without stay, my lord. There is nothing, we will not take any action. There cannot be any action in this regard. Staying would, my lord.
Will not take any action, Andre.
No, what is the action that could be taken? Nothing. Before it would be heard. There is statement. Based on that, we will have to do something. We will not file charge sheet.
Not even a complaint filed by any of the aggrieved person. It is a suo motu case registered, my lord.
Now, page 15 ಅಲ್ಲಿ ಏನು extract ಮಾಡಿದ್ದೀರಾ? ಕನ್ನಡದಲ್ಲಿ ಏನೋ ಇದೆ?
Lord, the interview given by the father of the deceased in a state, my lord, news channel, it has been reported. He has given an interview, video interview, my lord.
What do you say about this?
What
do you say about
22 he dies. I now collect statements.
That's all right.
Yes.
You said this petitioner has tweeted something. What do you say about this interview of the father of the deceased?
And it has been circulated in all media, my lord. The same news.
What do you say about this?
There should be an official inquiry towards the death of the person that he should say, because
No, that's all right. Now we are on tweet versus tweet or event versus
Yes.
event. Now this petitioner Tejasvi Surya has said something. Now this his father, the deceased father, gives an interview. In the interview, this is what is said. What do you say about this?
2022 he is.
ಅಲ್ಲ ಇದು ಅವ್ರು ಹೇಳಿರೋದೇನು ಹೇಳಿ sir?
What I'm saying is 2020.
No, it is on 8/11.
No, what I'm saying,
It was
Sir, maybe 2022.
ಅದ ಹೇಳ್ತಾರಲ್ಲ.
Now what do you say about the deceased father's allegation?
I'm coming to that. 2022 ಸತ್ತಾಗ ಇವ್ರದ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿರ್ತಾರೆ ತಂದೆದು. ಈಗ ಇವ್ರು ಫ್ಯಾಬ್ರಿಕೇಟ್ ಮಾಡಿದ್ರೆ.
You are not on a trial for that.
No, I'm not saying.
I'm only saying if you have to, point at this petitioner's statement, it is furthered by this statement.
Yes, I am confronted. Now in the afternoon, I am confronted with this statement. I will ascertain as to what he has said 2 years back when his son committed suicide. I am taken by surprise now at 2:30. Well, I'll have my say. Have it 2 days hence or next week.
See, illi he says, ಮೃತ ರೈತನ ತಂದೆ. That is the interview.
Yes.
You see,
ಅದು ಈಗ ಎಲ್ಲಿದೆ ನೋಡ್ತೀನಿ.
you see this interview, whatever.
Yes, my lord.
This is what is, he says that it is in the electronic media.
Yes, my lord.
ಅದನ್ನೇ ಇವ್ರು
Now,
ಮಾಡಿಸಿದ್ದಾರೆ.
Republic channel.
ಮಾಡಿಸಿದ್ದಾರೆ.
Republic TV.
Yes. ಅವೀಗ 2022 ಸತ್ತಾಗ ಅವ್ರ ತಂದೆ ಸ್ಟೇಟ್ಮೆಂಟ್
ಅಲ್ಲ ಅದಾಯ್ತು, ಹೊಸದಾಗಿ ಮಾಡಿಸಿದ್ದಾರೆ ಅಂತ ಏನಿದೆ?
What I am saying is,
ಹಾ.
2 years back, there is an inquiry regarding his death. There should be statements given by his father. Now, 2 years after that, why should his father give a statement now? 2 years after the death.
That that
He has
probably
gone
state
and
has to
given-
reopen that case.
My lord, now we cannot, my lord, we cannot go by the statement. We can only go by the statement uttered, whether it amounts to an offence under section 153 or not.
So your
Cannot fault
allegation
that.
is without fact check, he has uttered those statements.
No, the utterance itself, even otherwise, is bad.
We'll see. You file your objections.
No, I will have my, without objections, my lord. Objections may not be necessary for
Not
this.
necessary, yeah.
No, 153 ಗೆ statement to the
But
one.
argument I will take as heard.
My lord, I will place reliance on certain judgments and whether facts and circumstances in this would be the same as the Supreme Court would have applied.
No
for the-
problem.
Yeah.
I will permit you to seek variance of the order once you place everything.
But
Judgments
where is
could-
the, my lord, I am saying,
Ram Shiv Prasad Semal.
now the grounds of interim order, let us see, my lord. What is the grounds of interim order?
Yes,
We should go by that.
yes.
Yes. What is it that is going to happen? What is it he is apprehending? I shall be put to untold hardship. ಏನಿದೆ general statement. So therefore have it next week, my lord, we will.
I expect same vehemence when some other case also comes.
ಅಲ್ಲ ಎನಿ ಕೇಸ್ ಇದರಲ್ಲಿ ಯಾರು ಮಾಡಿದ್ರು ಇದು 153 ಅದರ್ವೈಸ್ ವುಡ್ ಬಿ ಪೊಲಿಟಿಕಲಿ ಮೋಟಿವೇಟೆಡ್ ಇನ್ ಎವ್ರಿ ಕೇಸ್ ಆತರ ಹೋದ್ರೆ ಸೊ ದೀಸ್ ಅಟರೆನ್ಸಸ್ ಆಗದೆ ಇದು 153 ಅಲ್ಲಿ ಬರ್ದೋದ್ರೆ ವಿಚ್ ಒನ್ ವುಡ್ ಕಮ್ ಇಸ್ ದಿ ಕ್ವೆಶ್ಚನ್. ಸೊ ಯೋರ್ ಲಾರ್ಡ್ಶಿಪ್
You submit, sir. No problem. You bring about the judgments and ಇದು 196, sir.
ಹೌದು.
ಅಲ್ಲ, what is the
353. 353 clause 2. Yes,
That
ma'am.
is 153A.
Equivalent to 505.
153. ಸೊ
505.
230 ಮೂವ್ ಮಾಡಿದ್ದಾರೆ, ಅರ್ಜೆನ್ಸಿ ಇರ್ಲಿಲ್ಲ, ಸ್ಟೇಗೆ ಗ್ರೌಂಡ್ಸ್ ಇಲ್ಲ. ಸೊ ದಿಟ್ ಶುಡ್ ಬಿ ಹರ್ಡ್ ಅಂತ ಅಷ್ಟೇ ನಾನು.
Well, hear it, sir.
ಸ್ಟೇ ಪ್ರಶ್ನೆ ಬರಲ್ಲ. Nothing is going to happen.
ಪ್ರಶ್ನೆ ಬರಲ್ಲ.
ಅಲ್ಲ, heavens are not going to fall. What is the hardship that is going to cause? Because the case is pending against him, hardship could be caused.
Yes. We'll see. The same submissions Jagdish will be doing later.
ಜಗದೀಶ್ ಮಾಡಿದವ್ರು ನಾನು ಆ ಕಡೆ ಎದುರು ಮಾಡ್ತಾ ಇದ್ದೆ.
ಅಲ್ಲ ಅದು ಬೇರೆ ಕೇಸ್ ಬಂದಾಗ.
ಬೇರೆ ಕೇಸ್ ಬಂದಾಗ್ಲು.
Yes. The petitioner is a parliamentarian, is now alleged of offence punishable under section 353(2) of the BNS 2023, which is 153A of the earlier regime, the IPC.
My lord, if I may, it's actually
505.
505(2) of, that's what I said, 196 is 153A.
Lord.
What, sir?
186.
196 BNS is 153A.
Please.
This 353, 505(2) of the IPC, the earlier regime. The allegation against the petitioner is in terms of a complaint, suo motu complaint on 7/11/2024 by the police inspector. The allegation in the complaint is as follows. The learned senior counsel Arun Sham, representing the petitioner, would also contend that for the petitioner would contend that when police issued certain clarification after the aforesaid tweet, the tweet itself is deleted. He would take this court through the interview to the media by the father of the deceased. It reads as follows. This is ostensibly after the deletion of the tweet by the petitioner. The reply to the question by the reporter would somewhat vindicate what the petitioner had said earlier, but the tweet has been deleted. All this, in the considered view of this court, albeit prima facie, would not become an offence or ingredients of offences punishable under section 505(2) of the IPC, as is held by the apex court in the case of 153 505(2) ondena most same. as held by the apex court in elucidating the identical provision 153A, which the purport of which is akin to section 505(2) of the IPC in the cases of Javed Ahmad Hajam, reported in 2024 4 SCC 156 and 2020 and Shiva Prasad Semwal 2024 7 SCC 555. Therefore, there shall be an interim order of stay of any investigation in crime number so and so against the petitioner. The respondent, the SPP would vehemently refute grant of any interim order. Therefore, he is at liberty, though he is heard in the matter, he is at liberty to seek variance with the interim order granted today on List this matter on, when do you want?
Yes,
10 days?
yes.
List this matter on 4th December in the fresh matters list.
Grateful.
Grateful, bro. Obliged.
Everything is
Grateful.
Bill number 4.
The petitioner was.
ಇದೇನು?
Petitioner number 1 was. I had moved your lordship's morning at 2:30 not to be taken.
Why? ಇವರು ಪಬ್ಲಿಕ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ಸ್
ಇಲ್ಲ. This is not,
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮ್ಯಾಟ್ರಾ?
ಅಲ್ಲ, no.
ರೆಗ್ಯುಲರ್ ಮ್ಯಾಟರ್. Why urgency, sir?
Please note, petitioner number 1, lords, entered into a joint development agreement with the complainant in the year 2018, under which not 56% allocation was for the land and developer, that is petitioner, 44% was for the landowner.
ಅಲ್ಲ, why 230 ಮೂವ್ ಮಾಡಿದ?
The reason is not now, JDA is completed. There is civil litigations pending between the parties. There was some amount of differences.
230 ಯಾಕೆ?
The reason is now the police have issued notice not asking us to appear.
Police have issued notice?
Yes, ma'am. But they registered in 2000, in July 2024, the NCR is issued. Thereafter, now they file fresh complaint before the learned magistrate. Learned magistrate directs investigation. But there is an order of injunction granted by this court in a writ petition between the same parties. PCR
reference.
ಆಯ್ತು, PCR.
I think there is a violation of 175(3).
Also.
Reference also.
Also, my lord.
ರೆಫರೆನ್ಸ್ ಇದೆಯಾ?
Reference.
Reference.
Where is the order of reference?
53, my lord.
Mr. Jagdish rightly points out, but in fact, I also wanted to say there is violation. But now under the new code, lordships are aware, the police
Sir, he is
officer.
one of the honest person. ಬೇರೆಯವರು ಇಲ್ಲ ಅಂತಿಲ್ಲ. He is
In all fairness,
so fair.
I appreciate it. I myself.
We've been able to complete the task of work because
no,
ಇವರು ಶಾಂತಿ ಭೂಷಣ್ ಇವರೆಲ್ಲ ಏನಂದ್ರೆ
No small.
immediately they get information and correct
No
information.
small.
Not leaving the SPP away.
ಅವರು ಹಾಗೆ, all of us, all of them are.
Yes, sir. Yes, sir. But ಏನು ಇಂಟರ್ ಮಾಡೋದು ಏನು ಕೇಸ್ ಇಲ್ಲ.
No, my lord, this is a
Appear
matter.
ಆಗಿ.
No, the reason is this, my lord. But kindly see, my lords, the agreement note which we have entered into. There at page, may I request lordships to kindly see the complaint at page, my lords, 32.
You should learn to relax and smile.
No, I don't know, lords.
You should always be smiling.
I was. I
But the
suppose.
tension.
I guess my age is catching up. We're getting older as.
ಯಾಕೆ ಸ್ಟ್ರೆಸ್? ಆರಾಮಾಗಿ. Your accused number?
There are two accused, accused number 1 and 2. Our tenant also has been made a party. But this honorable court, my lords,
Heard the learned senior counsel Prabhuling Nawadgi appearing for the petitioner. The petitioners are accused 1, 2, and 3.
No, 1 and 2.
Accused 1 and 2. The learned senior counsel would submit that the petitioners had a contract with the complainant Joint development agreement.
Joint development agreement.
Contract with the complainant, which was a joint development agreement.
Which has been executed.
Joint development agreement which was executed. And certain dispute that arose out of the joint development agreement was sought to be complained of initially. The police holding it to be a civil dispute render a non-cognizable report. After the rendering of the non-cognizable report, the petitioner, the complainant appears to have knocked the doors of the learned magistrate by invoking section 200 of the CrPC by registering by invoking section 223 of the BNSS 2023 by registering a private complaint. It transpires that the learned magistrate has referred the matter for investigation under 175(3) of the BNSS. The learned magistrate appears to have ignored or glossed over the fact that filing of an affidavit along with
Hearing of police officer.
Hearing of the
oh,
police.
ಇದು correct, 175(3).
Yes.
The learned magistrate appears to have glossed over the procedure of hearing the police officer prior to referring the matter for investigation under 175(3) of the BNSS, which is a procedure that is for the first time brought in under 175(3). Apart from the said fact, the learned senior counsel would submit that the issue in the list is breach of a joint development agreement, and there is an injunction granted by a coordinate bench of this court in writ petition.
This writ petition number 11798 of 2024. Order dated 5th July 2024.
Therefore, on all these factors, if further investigation.
I'm sorry, Lord, that it may be necessary. There is also a commercial appeal. In commercial, please, give both
with
of
all these factors,
Final order. Final order.
that is final order.
final order ಆಗಿದೆ injunction.
No, no, that is that remitting the matter back to the trial court after granting injunction. No, but
So ಮಾಡಿ. Injunction is granted by the coordinate bench while remitting the matter back to the hands of the commercial OS.
yes, no, commercial court.
Back to the concerned court in commercial OS, in a commercial OS. Be those submissions as they are. In the light of what is afore narrated, if further proceedings are permitted to continue against the petitioners for a breach of a joint development agreement, it would run foul of the judgment of the apex court, where all of you have done. Judgment of the apex court. Judgment of the apex court in the case of Vijay Kumar Ghai versus State of West Bengal reported in 2023 SCC Online SC page 124. Therefore, 2022. Therefore, there shall be an interim order of stay of further proceeding, further investigation. Pay these petitioners till the next date of hearing. List the matter on 12th December in the fresh matters list. 1 additional SPP, 2 emergent notice.
Please.
Yes, Sanjeevi madam, you should do all the research. 2022, 7 SCC 124. You have a battery of lawyers.
No, no, they must, they must work hard. I guess when sitting in a court, lordship's court hall also, Lord, they tend to learn.
Should all do research.
It's always a learning process. It's always a learning.
Yes.
Great.
Even for me, sir. Yes. We learn from the councils also. The youngest of the youngest councils also, we learn something.
Great.
Yes, sir.
For the petitioner.
Brajesh, 6 o'clock ಆಯ್ತು, ಇನ್ನೊಂದ್ ದಿನ ತಗೊಳ್ಳೋಣ.
ನಾಳೆಗೆ.
Yes. 311 application
Yes, ma'am.
ಇದೊಂದು ಅಪ್ಲೋಡ್ ಮಾಡ್ಬಿಡಿ, ಇದು ಮಾತ್ರ. The petitioner to serve on the council who represents the respondent in the trial proceedings. Special CC ನಾ?
ಹೌದು.
ಯಾಕೆ?
But CBI, madam. CBI is the.
CBI
ಹೌದು.
Trial proceedings ಅಂದ್ರೆ ಇವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿ. Counsel P. Prasanna Kumar is directed to accept notice for the respondent.
Yes.
A petitioner to serve set of papers upon the said counsel. List the matter on 22nd in the fresh matters list till such time further proceedings before the concerned court shall remain stayed. ಇದೊಂದು ಮಾತ್ರ ಅಪ್ಲೋಡ್ ಮಾಡ್ಬಿಡಿ. ಅಪ್ಲೋಡ್ ಮಾಡ್ತಾರೆ.
ಹೌದು. Thank you. Oblige.
This case, all further proceedings are already stayed, my lords.
What do you want,
At
ಮತ್ತೆ?
the instance of other accused, my lords.
I filed my lord's application before the trial court, my lords, for consideration of my lords, so as per my lord's judgment,
ಪಾಸ್ಪೋರ್ಟ್
passport, my lords.
ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
Short term passport, my lord. Stay ಇರೋದ್ರಿಂದ I cannot touch it
ಮಾಡಲ್ಲ
ಅಂತ.
Yes,
Filed an application for permission to travel.
true. The court has said that they will not consider unless the petitioner is back to the doors of this court on the ground that the concerned court has not considered the application of the petitioner seeking permission to travel. The reason for non-consideration is an interim order operating in the case at hand.
Please.
The
Not in the case, my lords. The other
interim,
accused has filed.
interim order operating in writ petition, in criminal petition.
Criminal petition 9570 of 22.
Therefore, I clarify that the interim order subsisting in the said writ petition will not come in the way of the concerned court to consider the application seeking permission of travel in accordance with law.
Stay up.
ಏನ್ ಇದ್ರಲ್ಲೇನು?
ನಮ್ದ್ರಲ್ಲಿ stay.
Huh?
They'll stay ಇಲ್ಲ.
ಏನ್ stay
Fresh
ಇದು?
petition, my lords. It's a 420 offense, my lord. PF department claims that, my lord, I have given, my lord, false information.
ಏನ್ ಪ್ರೇಯರ್ ಕೇಳಿದಿರ ಮತ್ತೆ ಇದ್ರಲ್ಲಿ?
That's one of the interim orders.
PF department ಇದು ಸೇಮ್.
PF department, same.
In so far as there shall be an interim order of stay of all, apart from the aforesaid observations, there shall be an interim order of stay of all further proceedings in CC 16190 of 2022.
Take one, buy one.
Huh?
Take one, buy one free.
ಅದೇ
ಅಲ್ಲ, R3 can consider, my lord, within 1 week from the date of order of trial court, my lords.
ಇದು ಬೈ ಟು ಫ್ರೀ ಆಗುತ್ತೆ, ಬೇಡ ಅದ್ರ ಒಂದ್ ನಿಮಿಷ. ಎಸ್,
Online upload ಮಾಡ್ತಾನೆ.
ಅದು ಮಾಡ್ತಾರೆ.
Tomorrow is the matter, my lord, trial court.
ಆಯ್ತು ಮಾಡ್ತಾರೆ. ಮಂಜುಜಿ ಅದೆರಡು ಮಾತ್ರ ಮಾಡ್ಬಿಡಿ, ಬೇರೆ ಯಾವ್ದು ತೊಂದರೆ ಇಲ್ಲ. DSJ accepts notice for the respondent, ಅದ್ ಮಾಮೂಲಿ.
Learned friend requested, my lord, therefore he told.
ಕರೆಕ್ಟ್,
that
ಆಯ್ತು. ಮೂವ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಹೇಳ್ದೆ, only if you get Shanti Bhushan, I will grant an order.
Correct.
2 emergent notice.
Two emergent notice. ಯಾವ್ದು? ಈಗ ಮಾಡಿ. Anytime. Next week. ಇವತ್ತು 6 ಗಂಟೆ.